Yes, Mr. If I put 38, what do you want, adjournment? What to do? You take your decision, tell us. That's why for us it is very difficult to take a call. You amongst yourself take a adjourn on the prayer with the ERPL and otherwise you discuss among yourself. You take your call. If you want us to take it, we are ready to take it. If you feel that it should be before the other bench, you point it up to the registry in that case. Because without there being a judicial officer, it's difficult for this court to say that it's either part or not. Same pattern.
No, it was not very matter, but he had to only produce a document.
So we don't know. Same answer from our side. You take your call. If you want us to hear, we are ready to hear. If you don't feel it's part heard, we'll adjourn it.
The order is not part.
You can take it up with the registry. We understand for the want the adjournment today. Adjourn on the prayer, Mr. Kiko. Fixed it. We will list it on. Yes, madam. Adjourn for the day. Yes. Want adjournment? Adjourn. Goes petitioner adjourned.
Item 1 for motion.
Yes, what is this matter? No, what is the matter about? No. See, Madam Chaudhary, it's difficult for us to take over from where the other court has left. If we hear, we'll hear it from the beginning. And if you want, you can place it before the other court. Because other court must have gone into the matter, applied some mind, pursuant to some material is required. We don't know what transpired that day. So how can I take over from a midway stage? So your option is either you begin from the very beginning, we'll hear it, or if you want to take it up with the registry, to be placed before the other court. Which one you would prefer? Beginning. Okay, please start. No, that's okay. Was it placed before? Actually, it was not placed, but a wrong information given. It was rejected twice. And then what happened?
That is why after that, the other early was dismissed. Dismissed because on the basis of the wrong submission that it was rejected twice for
Why it was again, why was it again placed? If it was rejected, writ petition also dismissed, why was it again placed? Anyway, after that, what happened?
Page 26.
Page 26. No. Page 26.
Ground floor rejection given is the open the order is on.
It is stated that by the time the writ petition was filed, 2 years gone by, the case was considered could not be recommended for consideration. So this is the present impugned order. And what information was sought for by the court?
Information was sought from two DLC decisions, dated 10/8/2009 and 10/8/2011. These 10/8/2010 people discussed the order of this honorable court of 2014. That is why it was called for, and I have annexed in my additional affidavit matter. Additional affidavit dated 25/7/2023. The petitioner submitted application under RTI number, and he was
Just a minute, I have not understood.
He was furnished by the
No. First you were saying it was placed twice. Then you say it was on the basis of wrong information. Then you say it was again rejected. Then you say you filed writ petition. Writ petition dismissed.
writ petition was filed on the basis of wrong information that my case was placed before the DLC it was rejected. But the fact is that it was never placed. The order reflects that there was a DLC dated 10/8/2010.
Please refer to the documents on what basis you are saying, because I am having difficulty in understanding what had happened.
Subsequently, this honorable court has passed an order dated 2020, asking me to punish these two DLC decisions. Kindly see the additional evidence. I have annexed the RTA application at page 39. So, dear madam, I have submitted application seeking the DLC decision dated 9/8/2010
Madam Chaudhary,
10/8/2011.
I understand.
But
But I have not understand the sequence of events. In patches, I have understood what had happened. What's the sequence of events so that I can understand where the illegality had taken place?
that is that on that particular date, no DLC was held, and it was informed my lord. So, but the question.
Then okay.
Kindly see page, my lord, 58
Madam,
of my application.
let me read the writ petition. Sorry, I'm unable to understand what has happened.
Here is the lordship, it is the minor, the official communication, minor page 58.
Page 58. Okay.
Of my additional affidavit. Additional affidavit.
Page 58, with reference to subject cited above, I am to submit unit information as sought for. No DLC meeting was held on, and so the
So the question of rejection does not arise.
9/8/2010, but it was held on 10/8.
9/8/2010, but this
Information was
no, ultimately what happened? Tell me, when did the person die?
the person died by the on 23/2009.
23, 2009, the person died.
Yes.
When did you make the application?
15/6/2009.
15/6. What happened to this application?
After that, my lord.
The first,
Yes, first application of visited the office and asked them.
I'm not interested in where he visited. What happened to this application? Was it considered or was it not considered?
My lord, he was informed that his case was placed twice and rejected.
Just a
Then
minute.
he filed this
Please go a little slow, so that I can understand what you are trying to say. On 15/6, one application was submitted. In which DLC it was placed?
It was not placed.
According to you, it was not
It
placed,
was not placed.
and according to them, it was placed.
According to us also, my lord, because we received wrong information that your case was placed and rejected. That is why the petitioner.
Do one thing, respondents to produce the complete reports of all the DLCs wherever the application of the petitioner dated. What is the date?
I have placed my.
10/8/2009 and 10/8/2007.
Another. 2010, it is reflected in the order of the honorable court. 9/8/2010. I have annexed the order of the honorable court, page 38 of my additional affidavit, my lord. Page 38, my lord. It is reflected in the order of the honorable court, my lord. Annexure 1, page 38, my lord. As per the petitioner, it was twice considered by the DLC, firstly on 9/8/2010. However, this case could not be recommended for want of vacancy. But the fact is that on 9/8/2010, no DLC was there. And it was, this information was only, my lord, to the petitioner, my lord, which I have annexed at page 68, my lord. They also informed me that no DLC meeting was held dated 9/8/2010. So the question of rejection that I think that the petitioner's case was never placed before the DLC.
DLC was around 10/8 or next year. Maybe I got to that. I got around 9/8/10/8, 1 day.
Okay, both of you are completed. The respondents to produce all the records of all the DLCs wherever the application of the petitioners for compassionate appointment filed on which date you filed your application.
15/6/2009.
15/6/2009 was considered.
I will
How much time you want? So that will make it clear. She says not placed, you say it is placed. So you produce the complete record wherever it was placed. When do you want, Mr. Keshav? Yes, sir. Recovery of. Yes, 12% retired. He died during service. From whom it is sought to be recovered? Pension of the wife. Can you do it? Where is the order? 38. No, 38 is a court order. Where is the impugned order? 27. Yes, pension department, who appears? Under which law is the page 27 order justified? Can you do it? Sorry. Sorry. So this person was working at grade 3, grade 4. So that's why I'm asking, can you do it? What is the order of the court? Earlier order you are referring? 38. What is it? I heard Mr. S. Alam, land counsel for the petitioner, also heard Mr. S.M. Chisti, land counsel for the secondary education department, and Mr. P. Saikia for the pension department. The husband of the petitioner, namely Fuleswar Dole, he served as inspector of school. Of the inspector of school. He was a grade 4 employee in the office of the inspector of school, North Lakhimpur. Let us say something more. Do you want to add something more? No, please complete it. Not in the middle of the order. And if you find something to be corrected, tell us at the end of the order, not in the middle.
Who was a grade 4 employee in the office of the inspector of school, North Lakhimpur?
Who was a grade 4 employee? Which school? High school. Died on 14/4/2021 while he was still in service. In the resultant circumstance, the petitioner, being his wife, is entitled to be paid the family pension in respect of the deceased husband. While processing the pension papers, family pension papers of the petitioner, the finance and accounts officer in the office of the director of pension Assam made a communication to the inspector of schools, North Lakhimpur, dated 14/6/2022, by which it was provided that the pay of the deceased husband of the petitioner ought to have been rupees 2610 per month instead of rupees 2770. And therefore, the finance and accounts officer is of the view that there was an excess payment of salary to the deceased husband of the petitioner from 1/1/1996 to 14/4/2021. Accordingly, it was but they have not deducted it. They say that they may be assessed with due drawn statement and resubmit the same with certificate of HOO, whether there was any fault on the part of the and accordingly, the pension papers were returned back to the inspector of schools for being assessed with due and drawn statement and for resubmission with a certificate by the HOO as to whether there was any fault on the part of the former grade 4 employee. The said provision in the order of the finance and accounts officer is perhaps by referring to the law laid down by the Supreme Court in Shyam Babu Verma and others versus Union of India and others, reported in 1994 to SCC 521, and State of Punjab and others versus Rafiq Masif, Whitewasher and others, reported in 2015 4 SCC 334, wherein there is a provision that in the event an excess salary had been meted to an employee who had retired in the meantime, but such excess salary had been paid not because of any fault on the part of the retired employee, the same cannot be recovered after his retirement. The element of the finance and accounts officer in the impugned communication of 14/6/2023 to find out as to whether there was any fault on the part of the former on the part of the husband of the petitioner appears to have flown from the said proposition. But it is noticed that the said proposition was rendered by the Supreme Court in a matter where an employee serves the complete tenure and thereafter retires, and the person is expected to be living for the person of his, for the purpose of his, for the purpose of payment of the pension. But in the instant case, it is noticed that the husband of the petitioner had died on so and so while he was still in service. Even if there was any fault on the part of the deceased husband of the petitioner in an excess payment salary being paid to him, the same would require a determination, and in such determination, the person concerned would also have to be given a hearing. As the husband of the petitioner is no more and there is no further opportunity of giving any hearing to him, we are of the view that the respondents now cannot make an inquiry as to whether there was any fault on the part of the deceased employee in providing the excess payment. Accordingly, the communication of 14/8/2022 of the Accounts and Finance Officer as regards a determination to be made as to whether there was any fault on the part of the deceased employee is accordingly sent aside. The pension department is directed to process the pension papers otherwise as per law and complete the same within a period of 1 month from the date of receipt of the certificate of the order. For the finance department. What do you say? The man died. So how can you make this inquiry? Sorry. For the purpose, all the other the respondents in the education department to also cooperate with the pension department by providing the necessary documents, etc., as may be required. That medical admission. How long will it take? How long will it take?
We have to have that inspection complete. It's a vertical inspection that was challenged before the Supreme Court.
Vertical, Supreme Court held it to be vertical. So therefore, one solution was found out that we increase some number of seats
That was
to mitigate the grievance of the general
I
people.
had a paper in the PG admission. But that.
So number of seats will be increased.
It is free. MBBS every year increase is not there. PG there was an increase this time also. Following my laws of earlier order.
But anyway, no one has challenged that. Ask me to take a seat. Bob? No, আপনি বহিল লইকে
Unlike in the other counseling, for the last 3 years, the counseling has been held online from COVID situation onwards. And as per the
last 3 years online and this year physical online.
no, as per the provision of admission, the expiring candidates after the
Mr. Wait a second. Let me read the rules once again so that you have it in your mind what is the actual requirement.
My lord will have to take
Page 2208. In the selection of the counseling candidates shall be called in order of merit. Mr. Mayor, take some time to understand the law. And only then make an attempt to implement the law.
The verdicts are could have been better.
No, it's too complicated a wording to understand in one word. Where is the schedule 3?
In the last was the end.
Have you annexed the rules in the petition? Okay, do you have the complete rules with you?
Yes.
Correct. It's your copy or you have some extra copy?
The amended part has been annexed to the petition.
No, I want to read the complete rules. But do you have any other copy for you? আপনার আরো একটা রুলসৰ কপি আছে নেকি? No, I may mark something. That's why I'm saying. Why to ওলাব পাৰি নেকি?
But it takes time, you can have a print of it.
No, date of make a print of it.
Well, this is a complete.
This one. Again.
This is 2017 and this is the.
Do you have a consolidated one?
Well, 2017 and 2020.
Okay, 23. Which one will be applicable now?
Well, so far as the rule is concerned, HC, it will be 2017. Schedule has been amended in 2020.
So, Schedule 3 referred in Rule 8C will have to be read as per the 2023. Where is the provision second preference? Somebody was referring that second preference.
The rule 8.
The Rule 8 where?
Second provision.
Provided, it's the provided that
Mhm. No.
Provided that the result category candidate by name B, C, and D.
Just under such circumstance, one of his next preference shall be. So now, Mr. Nair, the interpretation that was sought to be given the other day appears to be not so as interpreted. Okay. You are saying your entire interpretation, let us take the example of this day, serial number 294 or something. If day, he is otherwise EWS, because merit-wise, day comes immediately after the last general of Silchar. So, by invoking this proviso, now day should be considered to be a general. Okay. And second preference college of day, in that college, one general should now be converted to EWS. This was your entire submission. No, please, first you settle amongst yourself on your submission, because this is what we have heard to have been said. So first, you make sure what you have submitted.
What I have submitted, what I understood was that when a person goes as a meritorious MRC, meritorious result candidate, because he's coming on merit.
You were relying on the Supreme Court? Supreme Court was-
I'll just give it 2 lakhs what I want.
Supreme Court.
What is
different like what you
I go, I get a seat, my lord, saying God will get on merit. My lord will not go by the days and only on the proviso.
Okay.
My lord will not go by days. My lord, if I.
We'll go what Mr. Nair is saying.
No, my lord, what I understood, my lord.
No, no, please continue the way you are comfortable.
My lord, I get a seat on merit in Guwahati Medical College because of that,
Yes.
my lord, thing. But.
So
I-
just we have noted the line, I get a seat in
On merit.
Guwahati Medical College on merit as you are.
You are.
Fine.
But my lord, the proviso says, my choice is Silchar. My choice is Silchar. But in Silchar, my lord, the UR quota is not there. But a EWS quota, if I opt for my EWS quota, I get it in Silchar.
Okay.
So my lord, they give me Silchar as EWS by exercise.
So the first preference of this, your example man is Guwahati. Okay.
The first preference is my lord Silchar, but I'm not getting it there on merits.
On merit in Silchar.
Silchar, but EWS I get it. So I opt for EWS and I join them. They consider me, but they, in terms of this provision, they consider me as an UR.
This is where we are having difficulty. Please read it.
Gotcha.
Let us read it together. It will be easier.
Gotcha. Provided that a reserve category candidate.
Just a minute. Provided that a reserve category of 5A, B, C, D of the schedule. That means the 4 different categories.
And the EWS is also there.
Okay. Just a minute. Entitled for selection on the basis of his merit position in the general reserve category.
Gotcha.
So one condition, this man must be entitled for selection on the basis of merit in the general. This is the condition number 1.
Gotcha. Shall have.
Just a minute. Shall have the option of taking a seat in the college, not in that college, in the college,
Any college.
where a specified number of seats have been kept reserved. But while computing the percentage, so man A is entitled to a seat on merit as unreserved in Institute X. Okay. This man now wants a seat in Institute Y, where he will be entitled as EWS. So he gives his choice that from Institute X, please give me Y. And the authorities gives him the Y. So now he will be EWS in Y. When this will happen, the seat EWS which will occupy in Y will by virtue of this proviso, will now be converted to a general, and the EW seat of that Y institute will be brought to the X institute from where he was originally.
Or anywhere else.
No, not anywhere else.
I don't see that.
Not anywhere else.
I don't see that.
In the shall be deemed to have been and not reserved under the circumstance, one seat of unreserved of another college of his next preference.
Shall be
Converted.
converted to the respective reserve category of that particular candidate to maintain the total number of reserve candidates.
So, condition number one, if this man is entitled in X institute for a general, instead of accepting the general seat wherever he is entitled, he chooses institute Y. Only on these two conditions being satisfied, this proviso is applicable. Here is a case, give us the example of one candidate who was otherwise entitled an unreserved candidate in any of the 6 institutes, but had accepted the EWS quota in another institute. Which person? Find out. The person if you find out, we are going to invoke the.
That's what I got.
Find out.
That is the only thing about they have to discuss.
Please find out.
That's the end of it.
The example given of day is not
No,
applicable.
no, Madam, and they was just picked up. It could be anybody.
So now you pick up the appropriate one.
Any meritorious
So
candidate.
we'll take up after some time.
What should they have taken?
Mr. Guru, please make the entire list available. Find out who is the candidate. Otherwise, for day, we feel it is not applicable.
No, Madam. They was, I think, an example picked up. Madam, only thing is that provides.
Mr.
What
Nair,
my lord has now interpreted, that is the correct question.
the way day was picked up, we also took day to have been picked up and responded accordingly.
As far as
So now find out the appropriate candidate.
But I'm sure, Madam, my duty is that part which my lord.
Yeah,
That is done.
Yes. And Mr. Nair, thank you for the opportunity. It was really good help.
No, not that we could.
So this is the interpretation.
My lord, if a candidate meritorious, let me just say what I could understand. A meritorious candidate, I'm using that word, could not get the choice, the seat in a choice of his college.
No.
Madam, he gets it somewhere else, but.
No, sorry. This is where a little difference. You are taking the language of the Supreme Court judgment. That's why I wanted to bring the Supreme Court judgment. Here language is a general candidate is eligible to a seat in Institute X. Okay. Instead of taking the seat in Institute X, he says, please give me Institute Y, where I'll be entitled under the EWS. In the event of happening of these two events, he takes the EWS in the Institute Y. Once that seat in Institute Y will now be converted to an unreserved, and in lieu of that, one EWS will come to the X Institute where he was originally entitled.
So, Madam,
And this is the only interpretation of
underlying factor
this.
is because of that shift, the EWS reserve quota should not be eaten up.
Eaten
That's-
up.
That much.
And Supreme Court is also ultimately
Only on that.
to maintain
Only
the quota ratio.
And because of that, the 50% ratio is also not interfered. It will
That's-
be maintained.
So now,
Now, legally, EWS can be
now,
taken.
Mr. Ganguly, you go through the entire list, find out which candidate was entitled to an unreserved seat. But he says in the time of counseling that I don't want this one, give me EWS in the other one. If any such candidate is there, we'll ask the question. I think we are right in understanding.
Underlying factor is, Madam, the underlying factor is a meritorious candidate. Or he's a meritorious candidate, reserve candidate, should not be, might not given a discrimination with by a non-merit, lower merit reserve category candidate. That's the underlying factor.
So, kind of- No, underlying factor may be, but exact interpretation of the rules
That's what my lord said.
will implement the rules.
That
to
much
the
only.
full.
My lord will have to interpret that rules in the manner my lord has said. And the rest they should do.
If If you find out anybody,
Well, regarding the
Day
serial number.
no, day is gone now.
Day
Day was picked up, but now the now dropped out.
Because here the petitioner has pointed out BCL development with the serial number.
I know, that's why I remember that.
Our name appears in the arbiter category. But she has been considered.
No,
as
no.
EWS.
They, as per her, because this second proviso will also have to be read in the context of 8C. 8C, you cannot ignore it totally. 8C is shall allot a seat to the candidate MBS course in a college according to the choice of the candidate. So this is the first one. So according to the choice, they will offer, they will say that you are entitled to a this thing, unreserved seat somewhere. This person instead says that, no, please give me EWS of another institute. Only then it will happen, not otherwise. In general, otherwise you can't disturb the whole list because of somebody feels so.
But what has fallen from your lordship that he is entitled to a general seat anywhere. But his choice is Silchar, where he will get only an EWS.
No. First they will see which is your choice. This
Choice
like,
is, my lord said Silchar.
see, otherwise a proviso cannot make the general provision redundant. Unless the proviso is interpreted to be an independent provision of its own, the law of interpretation of proviso is it can never make the general provision redundant. General provision is allot a seat in a college according to his choice. You cannot disturb this one. So authorities will determine the entitlement only on the basis, first on the basis of your choice. If on the basis of the choice, a man is entitled to, suppose a man gives choice of Borpeta. Okay, Borpeta, suppose they say that it is little lower in the cutoff marks for Borpeta. A man gives choice in Borpeta. He is entitled to a general seat in Borpeta. He feels that I can instead try Dibrugarh because I fit into the EWS of Dibrugarh. Then only in that case, this man will be given in Dibrugarh, and that EW of Dibrugarh will now be brought to Borpeta. But if the first choice itself is Silchar, it is your first choice. Then these equations will not come in. Proviso will not come into play.
My lord, subject to what my lord would finally say. One, my lord, caveat from my side. That if he gets it, if he's a meritorious candidate, he's within the cutoff marks of the general community, then my lord.
This is not provided in the rules.
No,
Mr.
that's
Nair.
my caveat. That's my.
We understood. That's why I say the way it was interpreted the other day, this is where there is a little lacuna.
Because my lord,
The rules are
rules, yes, my lord.
explicit and clear.
That is
And if you
solid rules.
and if you want the rules to be in a different way, you challenge the rules.
Provided that the reserve category candidate is so and so, please check it. Entitled for selection on the basis of his or merit.
This
In
is
general,
this will be our example of the Borpeta man. Because Borpeta is supposed to be a little lower in merit. One man may be entitled on merit in Borpeta. He feels instead of Borpeta, I want to read in Dibrugarh. I fit in the EWS of Dibrugarh, give me the Dibrugarh. And then they are bound by this virtue of this proviso, not otherwise. But a first choice Silchar man is offered EWS, accepts EWS, he is EWS only. He is cannot be you are under any circumstance. You find, and if you want, we'll take up after some time also. You can have some time.
The position which I should have, I think is now clear.
So it's clear to your satisfaction.
But that caveat, I don't know why, man, it's still in my head. It's stopping me.
But if you read with 8C, that caveat goes. And 8C you cannot have it. Proviso cannot make 8C redundant.
And my lord, one more situation. I don't know whether it will arise. Say, I know I'm a very meritorious. I know my capacity. I only give Guwahati and people. Say, it says next preference. First Guwahati gone, I get it in paper. I don't give a preference, third preference. Possible situation. How the proviso would be then, my lord. Because they'll have to work up that, otherwise that EBS will, my lord, vanish.
No, possibly you will be out.
No, I get it. I get it.
No. Possibly, without minus the quota also you are out. So as you are minus the quota, you are out.
No, because.
Suppose, I understood the example. A man considers himself to be exceptionally meritorious. He is so confident he gives only Guwahati and Dibrugarh. He is a EWS. No, suppose he is EWS. He doesn't get on merit in either of the two. Okay. But he sees that, yes, with this one, I fit into EWS of another one. Or I even fit EWS of Guwahati or Dibrugarh. He'll take it.
That's one solution.
And suppose he gets EWS of some other institute, he will get it. And these are for them to work out, not for us to deliver it.
That situation is not emphasized.
Then the rules are defective. Challenge.
Anybody can do.
You're open to challenge the rules. If it is,
Only use that.
but
Finally,
a caveat on from that point of view
not on that. The first
also cannot render HC redundant.
Malad is correct. AC is perfect.
As
But
long-
the proviso.
As long as entire rules are not under challenge. And we are not examining the rules.
So,
We are only
what Malad
implementing.
has said, AC is perfectly clear. But the exception that they are trying to carve out by the proviso. Malad, when Malad finally decides, Malad only will keep this. Maybe Malad that will settle many issues. What I said, that much Malad will keep it.
See, if a person, overconfident person,
No, I'm not on that.
just a minute, thinks, yes, I'm meritorious, only Guwahati I give, I'll not give anything else. There are many people like that. In fact, it happened with one of the most leading lawyers. It's a long time back, about 40, 50 years back. One very good ground was taken in an appeal. The assisting counsel wrote a few more grounds. Senior thought that other grounds are not required because this ground is more than enough to get the appeal through. Unfortunately, during the pendency to appeal, the proposed law was reversed by the Supreme Court. So,
It happens. But I'm not on that.
so for a meritorious student who is overconfident
It
and-
may happen.
and going by HC, if he gives only one or two choice and he doesn't get it, he's out. Because the others who had thought themselves to be less meritorious, but given the correct choice,
There you go.
by virtue of HC, they will get it. This one will be out. Unfortunate. What to do? And no one asked him to do all this.
No. Yeah, the question is that meritorious student will get according to his merit. I think EWS or a result getting given will not be discussed. That's the only underlying.
That's why what we initially say, three separate criteria. One is your absolute merit. Two is your reservation. Three is your choice. In fact, second is the choice. Third is the reservation. So choice has its own role to play. And it is for you to evaluate yourself and give your choice.
Let them move that out. If something goes up, then
But if somebody is found out, it's found from the rules that he had given choice of one institute on merit, he is entitled, but he had opted for another EWS in another institute. We'll take note of that. That's it. So we'll pick up after 1 hour or so. Yes,
Item 4,
yes, I report. I don't know the pair. I'm not going to give you.
item 5, permission.
Yes.
I'm in awkward question.
Why?
So, okay, section 11 is was filed by partnership of consisting of three partners.
What is this? Arbitration.
So,
Arbitration आहे नाही आहे.
here what I was
Anyway, we were not on that. So what do you want?
one of the partners, and from the here, they have the form. And only two.
Partnership business,
How many is the partnership?
maybe unregistered also. If it is partnership business, and what is the dispute?
Regarding yes, we were using our while there is a bit of requirement also. The bit of
No, Mr. Sharma, we are asking you this question because in respect of criminal liability, suppose today one partnership firm is existing. One of the partners had left a firm. And after the firm is left, he leaves the firm. The firm involves in some criminal activity. That partner is also liable. The partner who had left and the criminal act took place after he left, he still continues to be liable in criminal law. So this is a dispute of criminal nature or civil nature. What is the law in civil nature?
in the civil nature.
What will be the law if the dispute is of civil nature? Will the liability of the partner who left will remain or it will extinguish? I think it will remain. So once it remains, it doesn't matter where your partner, whether your partner has gone out or he doesn't have.
They are objecting section 11. That was an argument. Here on what here instructed me that third partner has left the firm. This Sanjay Kumar Mishra. One instructed me that not to appear on behalf of it, but other two partners instructed me to appear. So what
They're one party or two other parties?
that was the eighth number.
No, how many?
Petition has been filed by three partners. Petition has been filed by three partners.
But tell you, no, petition has been filed by two persons, Eastern Cargo and Natwarlal Mishra.
No, also partnership of
Hearing for the petitioners.
yes, for all of it.
No, who are the petitioners? Please come to the cost.
The petitioners, Eastern Cargo Movers, consisting of.
And Natwarlal. You represent these two?
No, Lord, these two, not, represents all the three laws.
Mr. Sharma, do you represent Majors Eastern and Mr. Natwarlal? Yes or no?
Yes.
Yes. Then
Then also, it is Parana page number 10 laws. I will go to page number 10.
what is the page then?
Affidavit.
Natwarlal.
Yes, hereby I am the one of the petitioner and duly authorized by the petitioner company. Which we are understand. It is all the partners laws. It's representing all the partners laws. Here also, I may be allowed to, this partnership agreement, we have agreed with another partnership company. So I may be allowed to place this partnership. I may be professionally programmed.
No professional problem will protect you. Your man will be in professionally problem, your client. He cannot do it.
One partner.
Under the law, your client cannot do it. Not that you cannot do it.
One of the partners is Sanjay Kumar Mishra asked me not to appear.
He cannot. We'll issue notice to this Sanjay Mishra and initiate proceeding against him for on the ground of criminal contempt. He's impeding the administration of justice. He cannot do it. How can he do it? There are two petitioners. Petitioner number one, MS Eastern Cargo Movers. It is a partnership firm. So we have the firm before us. Two, the firm is represented by Natwarlal Mishra. So the area of parties is complete as far as the court is concerned. Now, another person name you were saying.
No, I may be wrong, but here they have formed, they have reconstituted the form. This form does not exist. As of now,
But this dispute is on the basis of the earlier existence.
so I want to.
And You cannot, will not allow you all these things. Then tell your Mr. Mishra that this is rejected. We'll proceed with the matter. Now tell us what to do. You want to go ahead or not? Otherwise, we feel that this is maybe impeding the administration of justice by taking all these acts. Tell them. Not permissible in law.
That case, may I be allowed to file another petition? Can you file a fresh one?
You are always at liberty to withdraw your petition. No one can stop you.
Still liberty to file a fresh one.
You won't be allowed. Any litigant before the court always has the liberty not to proceed this petition.
Because I want special, I want liberty also.
Liberty will be given. Yes.
Today morning, my parents told me that one of the original partners who has moved his petition, now is that he no longer interested to pursue that. That cannot be done, right?
It doesn't matter. He cannot do it.
So, but he is in a position, he is in an awkward position, so he wanted me to.
So if you want to withdraw, we'll allow you. Up to you, Mr. You take instruction from your other clients also. Before withdrawing, because others may now again come against you. Why did you withdraw this petition? Come back, tell us. Internally, what is going on cannot have a bearing in a court proceeding. It's okay.
After 2 days.
After 2 days. But it will be after 2 weeks, not after 2 days. Adjourn on the prayer of Mr. B. P. Sharma, Land Counsel for the petitioners, to be listed again also.
Okay. 6 and 7.
Adjournment. Chakraborty. T. Chakraborty petition.
Okay.
Mr. Das, you appear. Any objection to the adjournment? Only want a fixed date.
Item 8.
The respondents who appear. Mr. Chisti, you appear. Elementary Education Department. Are you ready? No. Mr. Phuban, if you are ready, tell us. We'll proceed with the hearing. If you are not ready, we'll adjourn it. Adjourn on the prayer of Sayyid Phuban. But next time, please.
Item 9.
Who appears for the department? I think you will have to give the actual reply. Have you gone through the matter? I think the ultimate issue is for computing the experience of 17 years for a graduate teacher. The division bench interpreted Rule 12.2.3 of the Assam Secondary Education Provincialization Rules and said that experience as a teacher in the high school should also be taken into account. Suppose a man is initially in the high school section, later on goes to the higher secondary section. You cannot ignore the high school part. Their argument is by following the same principle. If in a high school there are two parts, high school part and the ME school part, and a teacher was a teacher in the ME for a particular length of time, thereafter became in the high school, the length of service in the ME should also be taken into account. I think this is your argument. Are you ready with the hearing? Madam Saike is right or Mr. Roy will be right? Madam Sharma is just taking out the principle, not the actual law. The principle that was applied in that other division bench judgment says that by following the same principle, now my ME experience cannot be ignored. And more so, this school was amalgamated. And I think maybe her case will be, if you take the ME period, she will be senior to the other person. And Mr. Roy will be saying, no, you cannot take. So according to Mr. Roy's client, experience will start only after the date of graduation. Which rules will govern it? Understand the rules first.
2018.
Same book, Mr. Sharma.
Yes.
Which page? Page number
There's number 34, my lord.
34.
Yes. Madam, first kindly see the equipment to the post of vice principal.
Rule 14.
Rule 13.
Vice principal.
Yes.
And this is for the post of
In-charge principal.
in-charge
In-charge
principal.
Yes.
So whosoever will be qualified for principal,
Yes.
they will be also qualified for in-charge principal. So why are you reading 3 then?
No, my lord.
You should be reading 12.
12 minor, but here is coming from ME school and ME is higher secondary school. So to become a principal of higher secondary school, he must be a vice principal of that yes, right.
No, they from where are you saying? Which rule?
30.
13,
Yes, 34.
34 years.
Yes. In case of amalgamation, 13 given, rule 13
13
D.
D.
Yes, ma'am.
To the eligibility for the post of vice principal.
Yes.
Years of amalgamated higher secondary school, the assistant teacher of any school having requisite qualification. Okay. I mean, having 15 years in both ME and amalgamated.
Yes, ma'am.
So ME will also take note of amalgamated, whatever is the cumulative combined, that should be 15 years.
Yes.
Okay, now,
Then let's come to page 32 and rule 3 manner. Rule 12.3. The candidate must have gathered at least 5 years of service as vice principal in any of the provincialized higher secondary school. Or the candidate must have 17 years of teaching experience as graduate teacher in the higher secondary. So I did a review for SEMI school and 2017 it was.
And then what is a graduate school? How graduate school teacher is defined? What is the definition of graduate teacher?
From the
No, no.
in the graduate scale of
Which provision? Twenty-one.
Graduate teacher defines.
Includes the category of assistant teacher, classical teacher, right? Secondary school. So, graduate teacher means for whose appointment minimum qualification is graduate. Now, what is the minimum prescribed qualification for appointment of a ME ME school teacher? Let us go step by step. Wait here. Now, if you understand the requirement law first, then we can examine what facts are applicable. Otherwise, we cannot arrive at any conclusion. So now, Mr. Sharma, why you are asking? By clause 4, candidate must have 17 years, because admittedly this person is not a vice principal.
Yes.
So 3 is not applicable. So this person is a teacher. What is the requirement? Candidate must have 17 years of teaching experience as graduate teacher in any higher secondary school. Now, after the amalgamation, this is a higher secondary school. Now, whether this person is having 17 years as graduate teacher. This is the question we have to find out. Now, first let us look who is a graduate teacher. Only then the question of 17 years will come. Graduate teacher is for whose appointment minimum qualification is graduate. Okay. Now, as this is an amalgamated school, prior to amalgamation, what was the prescribed qualification? Was it graduate or it was not graduate? Please find out that one. Mr. Kosi, one more. Suppose there is a ME school. These people will be qualified for ME school. Just after that, you amalgamate with a high school. So they become a part and parcel of the high school now. So now they will be teachers of a high school after amalgamation.
They will be teachers of a high school, but their appointment was initially as an intermediate teacher. In case of
So,
science,
where is your appointment letter? Page number. Page 20. person with the government letter detail, Santanu Kumar Das, passed BA of village service, is hereby temporarily on ad hoc basis as science teacher. Now, what is the qualification for a science teacher?
Specifically, the
No. What is the qualification for a science teacher?
1981 rules or the elementary rules. It doesn't say about anything about science teacher, but the qualification prior to 2005 was matriculation, and after 2005, it has become as the minimum
So now,
qualification.
in fact, that is why this question was asked. Now, when we interpret Rule 2.1, graduate teacher, who is a graduate teacher?
minimum
Whose minimum, for whose appointment minimum qualification is graduate. We take the qualification as it existed when that appointment was made, or the qualification as it exists today, if this kind of appointment has to be made. No, otherwise this will have some further implication. Now, this is a definition that is brought it in 2018. Okay,
it was there in 2003.
this definition is brought in 2018 because it's a rules of 2018. When the rules were framed, the rule-making authority was of the view that to be a graduate teacher, we feel you must be having the minimum qualification of graduate to be a graduate teacher. Okay. Now, this rule-making authority, while providing for this one, he had taken the minimum qualification as it existed in the 1980s or 1990s to frame this definition, or he had taken the minimum qualification as it exists as on 2018 to frame this rule. Because it's a very tricky question, my dear. And you can think over it and tell us later also if you want. If you say that the rule-making authorities had kept in mind the qualification as it existed in the 80s and 90s and then framed this rule, then what will happen is a large chunk of people will be excluded from being included, because when they were appointed about 20-30 years back, the minimum qualification was different. Okay. So that test will be relevant. What it existed long back, or the test will be what it exists today. If the test it exists today, we are only required to look into whether this person has the graduate or not, qualification graduation or not. If it has, it satisfies the requirement of this definition. If you take the basis to be the 1980s and 90s qualification, then a large number of people will be wholly excluded. Why they will be excluded? Because 30 years down the line, one rule has been framed that graduate teacher will only be those teachers for whose appointment qualification is graduate. So you are drawing a classification between two classes of people. So you are drawing a classification of two classes of people. One class will be those class. One class will be from a particular given year, qualification is made to be graduate. Okay, and they will be included as graduate teacher. And another class of the same category, same teacher, same duty, everything else is same. But when they were appointed, it was not graduate, so we exclude them. If you do that, will the test of Article 14 be satisfied? What will be the interlegible differential between two classes of people? People who were appointed after the given year when the qualification was made graduate, and another class for the same purpose, they were appointed when the earlier rules did not require graduate. Is there any intelligible differential between the two classes of teacher? No. Now you submit.
Sorry, it was not 1981. The Britishers earlier were covered by the 1973 elementary rules. Because at the time of their appointment, she was in the elementary schools in a ME school. That ME school, the qualification is given by page 296. If this
296, yes.
the for appointment of a teacher in elementary schools. The minimum qualification of a person to be eligible for appointment as a teacher in the elementary school shall be as per the notification issued by the state government from time to time in conformity with the NCT norm. These qualifications shall be applicable to category of elementary school in case of any relaxation. The lordship will find the fourth question. This is after 2012, the earlier amendment you have.
Science graduate teacher is BSc,
Yes.
and this person is a science teacher.
Or in respect of science teacher, because in any school of science teacher, they give the graduate skill of the also.
So then I think we need to go in favor of Madam. This teacher, the entire period will be included.
Because in case of other teachers, other than the science teacher, they
So
are
instead of deciding the question we raised, you find out that this is an alternative solution.
because in case of other teachers, other than the science teacher, though
But had this teacher not been a science teacher, some language teacher, then it
no,
would
then it will be he or she has
then the question
been
we
amalgamated with the high school.
then the
in the same status as an intermediate.
then the question we pose now it will be kept open for another matter where
Yes.
different category of teacher will be before the court. Yes, Mr. P.K.
You know, that decision given by which is for which the last order was found. You know, there, the
No, we need not go to that decision. That decision is rendered in the context of something else. Now here, straight away, we are deciding the issue. Is
that was for
Mr. Roy, suppose the court goes in a particular direction. It is not binding that you cannot retract, get away from that direction and you'll have to decide in that manner
I'm
only.
not saying that.
We are abandoning that.
I'm saying to the Lord,
That's
that
what we are abandoning.
specifically says, but you kindly have a look at Rule 12.
Mhm.
Things are there.
Which one?
Rule 12. Rule 12, G, sub-rule 3, clause 4.
Four, huh? A candidate must have 17 years of teaching experience.
Experience as a graduate teacher in any higher secondary school. Specifically says higher secondary school. Since graduate teacher in a high school was excluded, this particular rule was put to check. And the court interpreting this particular rule held that there the graduate teacher in a high school should be read in. This rule is not challenged. This rule here, primary is not, any school is not included. Since it was, high school was not included, this rule was challenged. And division benches held that there, this particular rule, along with the higher secondary, high school should be
High
read.
school should also included. Okay, fine. And now?
So now here, since elementary, the middle, ME school is not included, this rule ought to be challenged, my lord. This is my submission. This rule is not challenged.
No, no. Here, Mr. Roy, here, an ME school is not before us.
No.
What, no, what is before us is a amalgamated school. Number one.
Since it is say,
So, once the school is amalgamated, they'll now, from that day, they'll be solely governed by rules of 2018. Ah. Once they are governed by rules of 2018, the amalgamated school, being a higher secondary school,
yes,
higher secondary school, will also include all the teachers in it.
since it is specifically say higher secondary,
We
the
understand
rule
your,
making authority has
Mr.
said
Roy.
higher secondary.
no, we understand your,
Experience as a graduate teacher in a higher secondary. Now, here under the amalgamation rule, the teacher from any school cannot teach beyond class 8. That is also provided beyond class 8.
where do you get it?
Yes, there is there.
In which room?
You know, in the rules of amalgamation, the amalgamation scheme.
Which page? Page number?
I like to do that. My lord, will kindly come to page 60. Page 60, continuous page 60.
Page number 60.
Yes, page 60. And you will also come to page 62. Page 62 cross 5. Down
Clause
below.
5.
Also got it. After the amalgamation, teacher of amalgamated school state classes, teacher of LP class 1 to 5. Teachers of existing ME 1 to 8. That is what was behind it, you know.
Understand what you're saying? So you mean to say, after amalgamation, the teacher of a ME section retains his identity as a teacher of the ME section because he teach only up to class 8,
That's right.
not beyond that.
Not beyond that.
So as his identity as a ME school teacher is retained, even after the school is an amalgamated higher or higher secondary school, the clause 4 has to be read that 17 years of experience in any higher secondary school
Exactly.
will have to exclude the ME section. This is the sir.
That's just my submission.
Yes, Madam Secretary, what is your submission? And Mr. Kaushik, your submission? What do you say? How do you respond to the submission of Mr. Roy?
And even seniority is not relevant.
No, qualification is not relevant. Relevant is by referring to the scheme of amalgamation. He says that after amalgamation, the teacher of the ME school retains the identity as a teacher of the ME school because he cannot teach beyond class 8. He'll continue to teach only up to class 8. Only thing, instead of going to the original school, now he'll go to the amalgamated school. Once he can teach only up to class 8, that is, he's a ME teacher, whether his experience as ME teacher will also be teaching experience in any higher secondary school. Because otherwise, what will happen? A ME school teacher, similarly, one LP school teacher after amalgamation can also, now it's a question of being the principal of a higher secondary school. Higher secondary school is a little 1 or 2 levels higher than the ME. If the person does not understand anything of the higher secondary levels, how can he become the principal? This is No, no, this school was merged by which scheme? Page 62 scheme or page 95 scheme? No, they were merged by 95 scheme or by the 62 scheme. Where is the order of merger?
Order merger is page 77.
77.
And her name is, his name is kept below me.
Page 77.
Page, no, page
Not 77.
27.
27. No, no, this is dated 6 June 2017. So amalgamation must have taken place as per the page 62. No, sorry, it cannot be. No, no, Madam Saikia, this scheme is dated 3rd August 2021. Amalgamation took place in 1970 to 2017. So how can it take place on the basis of a future scheme when it did not exist on that day? Definitely the amalgamation was under this. Where is the beginning? Under the page 60 scheme. It cannot be under the 21 scheme. It has to be 60. It has to be earlier. 16 scheme. Because nothing can happen on the basis of something future that is going to happen.
22nd September 2016.
This one. Right.
Russians of the government.
Right. So now he submits that as per this scheme, this man is teaching the hands. And how does the government interpret this? How does the government interpret this issue? How does the government interpret this issue? Mr. Roy says that as per the scheme of amendment, any school teacher will teach only up to class 8. Although it will be in the amalgamated higher secondary school, but he will teach only up to class 8. Meaning thereby his identity as a ME school teacher is retained. Only thing, he will become a teacher of the higher secondary school. Now, Rule 12.3.4 says candidate must have 17 years of teaching experience as graduate teacher in any higher secondary school. As because his identity as ME is retained, will that experience be experience of teaching in any higher secondary school? Which a division bench says now to be read also as high school.
I think because in case of principal, it says higher secondary school. However, in the case of vice principal, there is a distinction. Then MD, you also will write 13D. There is a distinction.
13
Yes.
of ME of ME and B school.
Yes. For the post of vice principal, these teacher, amalgamated teachers, total experience will be counted, both in amalgamated and in the high school. But in case of principal, one of this distinction is not. It clearly says in high secondary school.
So how? But again, if you read 12.3.3, 5 years there. So if one man by virtue of 13.2D becomes the vice principal and continues for 5 years, then he can also become a principal. So there will be one stepping stone, but directly no.
Yeah, my lord, this is class 11 and 12 only. Not up to 8. So there must be some intermediate letter or something like that.
Who represent the school? You represent the school. but you can get the records. An issue has arisen as to whether a teacher who is originally a teacher in the ME school, after the ME school gets amalgamated with a higher secondary school, would be considered to be a graduate teacher in a higher secondary school under Rule 12.3.4 of the Assam Secondary Education Provincialized Schools Rules 2018. We also take note that by the judgment of the division bench rendered in Hogendra Das and others versus State of Assam and others, reported in 2019 1 GLT 583. Rule 12.3.4 had been read down to also include 17 years of teaching experience in any high school, which may also be a part of a higher secondary school. It is the submission of Mr. P.K. Roy, Learned Senior Counsel, for the respondent number 6, that as per the scheme of amalgamation, as per the OM dated 22/9/2016, upon being amalgamated, the teachers of the existing ME school shall be entitled to teach only in classes 1 to 8 and not beyond. Accordingly, it is the submission of Mr. P.K. Roy, Learned Senior Counsel, for the respondent was so and so, that the writ petitioner, being originally a teacher of the ME school prior to the amalgamation, would now be entitled only to teach up to classes 1 to 8, and therefore his teaching experience cannot be that of the teaching experience as graduate teacher in any higher secondary school stroke, which also includes the high school section of the higher secondary school. These are insignificant differences. Hardly makes any difference in the article. See, I have now forgotten what I was about to write. That's why I always request, please don't disturb when I'm writing the order. Now I've forgotten what I wanted to write. Because you lose the track. Now, once you say something in between, you happen to lose the track what you were saying. Then I will hear you again. List again, let's wait for. Next step. We'll hear you again once again. See, we need a lot of concentration to do our work. So once it is, I'm not to spend another 1 hour for this matter now. On some other day, we'll hear you from the beginning. We'll hear you from the beginning of the next day. I wanted to formulate a question so that on the next day I can complete the hearing. Sorry, no, not today. It will be. So, the other one order is almost complete. Yes, I just wanted to add one line. I can pick it. But I don't know why a small request cannot be kept. Always, because what happens, you see, after great deal of concentration, you form something that either a question or a complete view. If you disturb it in between, it goes away. You lose your track, what you were saying, and then you can't recollect. I don't know why one small request cannot be kept. So you are always ready to add, correct anything if you tell it at the end of the order.
this issue will help us in other cases.
It will have a lot of effect. It's not that,
We're discussing that. This issue will answer.
and it appears the issue is not answered till now. It's open question. But however, M. Cycle and Council Petitioner states that on facts, the petitioner is also required to take classes in what she said,
11
in classes 11 and 12, and therefore the distinctions sought to be made by referring to the clause in the amalgamation clause that a teacher of the ME school after amalgamation shall teach only in classes 1 to 8 may not be applicable in the present case. The respondents to produce the records of the school concerned regarding what nature of classes are being taken by the petitioners. This for a hearing. And tell Madam Secretary.
Item 12.
After some time. Next.
Item 13.
This is coming first time after motion. You want to file affidavit? Or
Rejected on the 2 years salary.
this conversion? Which page? Which page?
Page 26. The application of
Yes, Mr. Second, what do you say? See here, the quotative provision, if the applications of remain pending, cannot be considered due to want of vacancy for 2 years. Did you consider it and arrive at a conclusion that there is no vacancy, it cannot be given? Or you simply kept it in the file? See, suppose it was placed before DLC, DLC deliberated, found that for this man, vacancy is not there. Again, you place it, again, you find no vacancy. Ultimately, in the meantime, 2 years go by, then you can invoke this one. But if you never consider it, the application comes, you put it aside. And after 2 years, say 2 years over, nothing big. That will be arbitrary. What was actually done? The claim of the petitioner for compassionate appointments could reject it by invoking the provision of the OM dated 2012 that if application remains pending and cannot be considered due to want of vacancy for a period of 2 years, all such application will require no further consideration and must be understood to have spent its force. A question would arise as to whether the application of the petitioner was given its consideration but could not be recommended because after deliberation, it was found that no vacancies existed, or it was a case where the application was never considered, kept aside, and at the end of 2 years, the stand is taken that it has been disposed. Respondents to produce the complete records and information on that extradited response. So otherwise, it will be very easy. We don't like Mr. Ali, Mr. Ali's application. So keep it aside. Next, you see Mr. Sharma. Sharma is good. Bring his application. And Ali's application after 2 years, you say, it has spent its course.
Fourteen to 18.
Yes, Madam Devi.
Non-provincialization of the high secondary school. Everything is already being done, it's government matter, but.
Under the 17 Act.
17 Act. I want that disposal matter, because let the matter be discussed, place before the electoral matter, they will scrutinize the.
DLC had approved. And SLC,
SLC,
is it required or is not required?
SLC is
Not required. It will go directly to the director. And it has already been placed before the director. Let the director take a 45. Third, I was KDP, that council for the petitioners. Should we pass a common order or?
common order. I have come with the district wise. Decision is going for a district.
I don't really think that they will file separate application so that they are being
Yes, sir.
Writ petition 1200/2023 has been instituted by 27 writ petitioners, all of whom are the teaching and non-teaching staff of the Dubapara Higher Secondary School. The different schools are the Dubapara Higher Secondary School, Dubapara, Dohikata Bhojmala Higher Secondary School, Goziazani, Torongapur Higher Secondary School, Tulsibari, and Halimali Higher Secondary School, Lokhipur, in the Gwalpara district. Rest, Madam Devi, in a piece of paper, you write down the other petitions, the name of the school in the same manner. All the petitioners claim that their respective cases for provincialization under the 2017 Act was given a due consideration by the respective district, what is called DLC, district level committee, by the district level committee of the respective districts for provincialization. And it is stated that the respective DLCs had in fact recommended provincialization in respect of the writ petitions. The grievance of the petitioner is that upon there being a recommendation by the district level committee, there is a further requirement of the Director of Elementary Education to give a consideration to such recommendation and pass a written order thereon. But in the instant case, although the respective district level committees had given the recommendation, but the Director of, say, Elementary Education Assam is yet to give his consideration to the same. Where are the recommendations? I think I'll have to write some more facts. The recommendations in favor of Dubapara School had been rendered by their DLC meeting dated so and so. Give this particulars. Then total how many schools are there in the 4 writ petitions? First writ petition, there are 4 schools. And the other writ petitions, whatever is the number of schools, you just give it that X school by recommendation dated so and so, Y school so and so. It will complete for that paragraph. As the limited grievance of the petitioner is that under the rules of the Provincial Act of 2017, there is a requirement for the Director of Elementary Education to also give a consideration to the recommendations made by the district level committees. Therefore, we are of the view that the petitioner is entitled to a direction to the director that the respective recommendation, that the recommendations made in favor of the respective schools by the respective district level committees be taken into consideration by the director examine the same as per entitlement and pass a rigid order thereon. To facilitate the process, the respective schools to submit individual applications before the director along with a certified copy of this order, stating in detail the recommendations that may have been made by the in respect of the schools by the district level, and upon doing the needful, upon the representations being submitted, the director shall pass a written order thereof within a period of 2 months from the respective dates of the representations as may be made, disposed of accordingly. Town of Kulkivan.
State level scrutiny.
State level scrutiny committee. So director question, state level scrutiny committee.
No, no, state level.
Whosoever it is.
19,
No affidavit.
In question to the order passed by this honorable court, my lord, DLC minor, the commander my name to the post of assistant teacher in the LP school. Our my lord, the SLC declined.
Where is the DLC and where is the SLC? Which means
DLC my lord, the student question my lord, page 37. Item number 2.
who is it? It is Zairul Islam.
Yes, sir.
Zairul Islam. Zairul Islam discussed in the meeting with. And where is the SLC?
SLC division question my lord, page 38 my lord. Serial number
Zairul Islam. What is this? Rejected due to non-availability of norms. As per OM dated 16. What is the norms as per?
Normal 1 year, within 1 year. But this notification is my lord,
But where is the earlier High Court order?
earlier I took one of my lord, page 75 my lord.
Yes, Mr. Saike, what do you say?
Page 40 my lord, 1 order.
Page number 32, what is it? Date of application is 26/2007. Mr. Saike, come to page 26. So, when the earlier writ petition, you did not take this plea. Can you take it now? Will it not be barred by res judicata? In an earlier writ petition, you had the opportunity to take this ground, and not only taken, even the court had taken note of it. That died in 1998, mother submitted application in 99, seeking liberty to submit when the person will attain majority. But you have not objected at that point of time. Had you raised your objection that 1 year gone, we cannot do anything more, you did not raise it. And having not raised the plea, can you raise it in a subsequent proceeding? No. We are not on minority and majority. We are asking you same objection when available in the earlier writ proceeding, having not taken. Will it not be barred by res judicata in a subsequent proceeding? Then you cannot take it. You consider it as per merit. Third, Ian Bolmere, the counsel for the petitioner, also heard Mr. P. Saitya, the counsel for the deputy commissioner. No, for both correspondence number 2 and 6, not 6, 2 and 3, respectively, being the state level committee through the chief secretary and district level committee Kachar through the deputy commissioner Kachar. Also, Mr. Ganesh Pegul and correspondent 1, 3, 1, 4. 5 and 6 being the authority under the Elementary Education Department. The father of the petitioner, Nazrul Islam Loskar, was an Assamese language teacher in the Ghograbar ME School in the Kachar district, died in Hanes on 10/6/1998, and on his death, the mother of the petitioner, MUSTT Fatima Bibi, submitted an application on 15/2/1999, seeking liberty from the authorities to make an application for compassionate appointment when her son, the petitioner, would attain his majority. Upon attaining majority, the petitioner submitted an application for compassionate appointment on 2/6/2007. When the state application was not given its consideration for compassionate appointment, WPC 1639/2022 was instituted, wherein a final consideration was given by the order dated 7/3/2022. By taking note of the proposition laid down by the Supreme Court in N.C. Santosh the secretary is unable to take the dictation because they record sound. When two sounds come, one from my side and one from your side, they don't get anything.
A final consideration was given on 7/3/22 by taking note of the proposition laid down by the Supreme Court in NC Santosh.
The state of Karnataka and others reported in 2027 SCC 617, which provided that norms prevailing on the date of consideration of the application would be the relevant aspect for compassionate appointment. Be that is may, what is noticed is that when the facts of the case was noted, that the deceased employee died on 10/6/1998. The mother made an application on 15/2/1999 seeking liberty to make application for compassionate appointment upon the son attaining majority, and the son having submitted the application on attaining majority, on 2/6/2007, no objection was raised by the respondent authorities that the application subsequently submitted upon attaining majority could be untenable in law. In the circumstance, the matter was remanded back, was directed to be placed before the DLC of Kachar district for its consideration on merit. The DLC in its meeting dated 10/5/2022 considered the application of the petitioner made on 2/6/2007 and was of the view that the application that the required qualification for the petitioner would be higher secondary or its equivalent, and accordingly recommended the petitioner for compassionate appointment against available vacant post. When the recommendation of the DLC was placed before the SLC in its meeting of 26/8/2022, it stood rejected by providing that as the candidate applied beyond 1 year of the death of the employee concerned, the same is rejected in terms of the OM dated 1/6/2015. Mr. P. Saikyan and counsel for the respondents in the SLC clarifies that the relevant provision relied upon by the SLC in of the OM dated 1/6/2015 is that an application for compassionate appointment is required to be made within a period of 1 year from the date of the death of the employee concerned. As already noted above, in the earlier petition WPC so-and-so, although the facts were clearly noted by the court, no such objection was raised by the respondents that the application does not require a consideration as in terms of the OM dated 1/6/2015, the application is to be made within a period of 1 year from the death of the employee. The said order having attained its finality, we are of the view that the SLC in a subsequent proceeding cannot take the said view and now reject, inasmuch as it would be barred by the principles of constructive res judicata. Accordingly, the rejection by the SLC in its meeting of so-and-so for the reason that the application was made after 1 year of the death is set aside, matter remanded back to the SLC to consider the recommendation made by the DLC dated so in favor of the petitioner on its own merit and pass a reasoned order to be placed before the next available meeting of the SLC. Maybe we are not saying anything on that. We are saying it is barred by res judicata. You cannot take it now. Having not taken it earlier, now you cannot take it. Mr. Sakia, we have not stated anything other than you pass your own order, whatever is on merit. We have only said you cannot take this ground because it will be barred by res judicata.
Item 20,
Your matter.
This case, my lord, I am praying for my lord, one time either.
One time.
Measures for provided, at least compassionate appointment, pay for compassionate appointment.
Court provided one time measure.
Yes, my lord, Indra, my lord, giving me my lord, assistant the staff, my lord, to consider, my lord.
Oh.
It is not considered.
But one time word is one time. It is not a continuous matter. Wazirul Nasa was about 10-15 years back. Then how can it be a one-time measure? Now it will be multiple time measure. Any other ground?
Other ground is that, my lord, I applied, my lord, then my lord, it is not be considered by the DLC.
Not placed before DLC.
Yes.
Just place it before the LC, pass whatever order you have to pass. Achha, he did not file an application. Okay, your stand is he did not file any application. Okay. Mr. P. Saikia, Land Counsel for the Deputy Commissioner. For whom do you appear? For the Deputy Commissioner, Haithak Kandi has obtained the information that the records do not reveal any such application for compassionate appointment being filed by the petitioner, and accordingly, the respondent intends to file an affidavit. Pray aloud, affidavit be filed. Sorry. You file your affidavit, whatever.
21 and 22.
Yes, Mr. Kayyum. Okay, it is a kind of a cross case. One petitioner responded, next case he is the petitioner, you are the respondent, and you appear for the other one. So now what is to be done? You want to file any affidavit? Fine. I'm a San Fukan elementary principal. How much time? 6 time to file the affidavit in opposition. The records pertaining to the seniority of the two petitioners be also produced before the court. Yeah.
Item 23.
What is there? 1994. What's the matter about? They in GMD means Jawahar Navodaya Vidyalaya. It's a school under the category of OBC, and that is refused. Now what happened? What's the grievance? Admission is refused. That you will be provisionally admitted. No, that's well. On what ground they have refused?
They have said that the OBC certificate, it's a thing, those are not computer. Because they need certificate from the deputy office. Nowadays, what happens? The OBC certificate will be applied online, and they provide a certificate which is digitally signed. And the certificate which is furnished by the petitioner. Those were issued by the or some other record process which has been countersigned by the deputy commissioners of the respective. So petitioner submitted that certificate.
Petitioner submitted in the old format.
Old format.
Now certificates are issued in the new format.
That new format, they
Yeah.
apply before the deputy commissioner. That is under consideration. That no certificate.
No. Electronic form certificates are introduced so that the things is expedited,
Yes,
not delayed.
But that was applied on 4th of July and 5th of July. That has nothing to be.
Who appears for the deputy commissioner? If some application is there, you pass an order and issue the certificate. Madam, you appear for the school, and for whom do you appear? You are with her. So once a certificate is regularized, I think you have no grievance.
I have kind of detailed affidavit. There are 3 similar matters, item number 23, 24, and supplementary is item number 49. In both these matters, what has happened is that the petitioners have not submitted their own certificate. They are submitting in most of the cases, they are submitting their father's certificate, which is not acceptable. The student requires to have
His own certificate.
own certificate.
Why don't you get your own certificate?
Just one more thing. What has happened is they're all aiming to be OBC under the regard to laborers' capital. That is where the problem has arisen.
They are not accepted.
Not just by the name of the first petitioner, Kanaklata Chauhan, they're all Hindi-speaking people here also. And in fact, the
I know,
lawyers
I
had the idea, had the
I
option of
understand.
dealing with the
No,
similar matter.
in some matters, we had referred it to that committee.
Unfortunately, till date, that proceeding has not reached its consequential stage.
That the committee has not decided.
They are not yet decided. They have met on 3 occasions, and yet they have not taken. a
Yes,
decision.
who appears for the government? You decide this issue.
Coordination committee also.
That what is called, that common name is there, no? That Supreme Court judgment. Madhuri Patil Committee. What is the status of the Madhuri Patil Committee? You decide these issues. See, you are playing with the lives of some students. The school is also helpless. They cannot do anything unless you decide.
2020 also passed that order. I have annexed that order in my affidavit. Till date, those children are.
And who is the authority in charge of this Madhuri Patil Committee? No. Who is the officer in charge? Who will be the chairman or heading that committee?
Yes, for my information, the commissioner or the secretary of the deputy is something for the-
Do you represent him? Can we have Mr. Thor? We'll sort it out. So our view is, whatever is the claim, it must be decided. Decided, bring an end to it. If you're entitled, get it. If you're not entitled, you will be out. And the difficulty, Mr. Bora, if you are actually not entitled as OBC and you get in, you will be depriving another genuine OBC, will be below in the list. This is where we are concerned. So we have to decide your case. Take a final call. If you are, you are in. If you are not, you please make way to the others. Give it time, like Mr. And anyway, what will happen? They will fix a date and ask Mr. Thor to bring specific information. It's a small question. You will, we'll refer it to the Madhuri Patil. We'll take a statement from Mr. Thor within how many, which date it will be decided. That's all.
24.
There is the only West school.
So,
we have.
Well,
West Caribbean.
West Derby.
Yes, I am a resident of West Caribbean.
Hamre.
Yes.
But your residence will not make you an OBC. Mr. Thor, long time back, we have referred to this Madhuri Patil committee, what it's commonly called, to determine whether certain people having the surname of Chauhan, who are generally Hindi-speaking people, whether they also belong to the ex-T-labor community, so as to be entitled to a OBC certificate. Fine. It's been reported that this was done in 2020, but no final decision has been taken. We want a final decision. Or else let the commission secretary remain present before the court, explain us why he cannot take a decision.
Some children, particularly, I remember that.
About 2-3 years back, some proceedings did take place. We didn't expect. Our view is take a final call. If they are entitled, say they are. If they are not, say they are not. But not to be kept pending. So now what we intend to do, Mr. We intend to refer these 3 petitioners, 3 or 4 petitioners, and we want the answer on before the next reasonable date. You call for your committee.
Now, we see these has gone through this social justice empowerment.
Then who appears for that?
My lord, R.F. Das.
Ask Mr. Das to come.
Now it's a different committee.
Mr. Thor, we understand. Ask Mr. Das to come. So what, Mr. Dhor, what actually we want is a final determination of this question. Because otherwise, lot of children are affected, the schools are affected. And not only that, if they are OBC, they should get in. If they are not OBC, they are occupying a seat of another genuine OBC, which will be little below in the list. Why should that person be deprived? Because somebody is making a claim and authorities are not determining it. So it's having a cascading effect. If you are not the authority, ask Mr. Casper. Very well, we will accept that. We'll take up after some time. Let Mr. Casper. We should not play with the career of this.
Item 25 to orders.
Yes, Mr. Doctor.
That was defective.
It stated that on the order which has been alleged to have been violated, appeal is pending, has been filed before the Supreme Court. Adjourn how much? 4 weeks. Adjourn for 4 weeks for further information. Yes.
Item 27.
Yes, Mr. Hawk. 2 weeks time granted to the respondent contenders for filing affidavit on the pair of Mr. B. Kaushik. List of the 2 weeks.
29 and 30.
No, it's okay. Have you filed affidavit? We only have to follow that decision. Heard Mr. S. Chakraborty, and also Mr. E.R. Pavitan, and counsel for the Higher Education Department. In this writ petition, the petitioners assailed communication dated 1/2/2022, same communication of the Undersecretary to the Government of Assam in the Higher Education Department, informing the Director of Higher Education that the Government of Assam in the Higher Education Department is unable to accept the proposal for appointment of assistant professors in provincial-based colleges who are from outside the state. It is stated that the communication dated 1/2/2022 and a similar communication dated 10/2/2022, where the subject matter in WPC 1268 and 1268/2022 and 1262/2022. And by the judgment dated 21/2/2023, both the communication have been set aside on the principle of violation of Article 16 of the Constitution of India. As the matter had already been decided, we are no longer required to make any further adjudication. Accordingly, writ petition stands closed by accepting the setting aside of the two communications dated 10/2/2022 and 1/2/2022 and 10/10/2022. The implication thereof shall follow, and the entitlement of the petitioners be also determined accordingly. Same order. Same order.
32,
With the parent, you wish, yes. Have you filed affidavit? You want to file affidavit? Mr. Ganesh Pegu, Lankan for elementary education pays for how much time? I think 4 weeks. It's a 2023 matter. 4 weeks time to file the affidavit. Pay alone this after 4 weeks.
33,
33 years. Although the office note dated 28/8/2023 indicates that no steps by registered post had been taken in respect of respondents number 7, 8, and 9. But it is stated by Mr. S. Chaudhary, Lanka petitioner, that the steps were taken on 28/8/2023 itself. Raised it to verify and proceed accordingly. You are appealing for someone.
In this particular case, also, the petitioner appointment provided respondent as well as the PhD obtained by the father of Senate. And the hospital directed that while he was working as a principal, a deputy professor, teacher of a former higher secondary school, as a regular teacher, he has undergone a BA course on a BA college. Document directed to verify the passes speaking order before selection. The reason from before the director has passes speaking order without the record, the inspector's report. Affirmation additional report is called and this court is directed to verify the inspector's report.
That is in the second round.
The other also the director has passed an order. They are verifying the inspector's report that is stated cannot be considered for consideration of principal.
But it's in respect of the petitioner.
Thereafter, logic is external goes to be removed by speaking order. Also, thereafter, they have had a review petition. The review petition was withdrawn. Thereafter, logic speaking order has been silenced. It's a late speaking order is silenced. And logic has purchased status order.
They are noticed.
Before that, logic petition has taken over in charge from the respect. These are also coming on the government.
Mr. Chaudhary, this is the worst habit a lawyer can develop. When somebody else is speaking in the middle, you start shouting. Let him complete. You'll have your turn. You cannot disturb the concept.
Thereafter, the inspector has focused on this. Why he has not complied to order of the court. And he has filed an affidavit stating his focus on this by the inspector. Here is status quo.
Sorry, inspector gives over to whom? To the petitioner. As to which interim order?
Interim order status quo. He is not holding a post of principal. He has been removed by the secretary of PTC. Status quo order is there. But there is no order of stay order passed by the collector. On the basis of status quo order, after making his chart by the petitioner, he is holding a post. That is why so was originally issued.
No page number.
Petition filed by them. On affidavit filed by them,
Page number.
Page number. Page number 59.
Status quo order is dated
Status quo order is dated
31/7. One day prior. And who are the private respondents?
Petitioner
Yeah.
here.
Sorry.
Petitioner here has principal is a private respondent. On the
No. You represent the vice principal. And if this person is not the in charge, the vice principal will become the in charge.
as per order.
So now question is on the qualification of this person. Where is the order determining his qualification?
Yeah, principal condition. This last order permission order for 641. Directly.
No, no. Where is the determination that he is not qualified?
Page 49.
Page 49.
This is the speaking order subsequent to last court's order.
27 July 2023. So this order is challenged in this state petition. On what ground?
Yes,
No, now, yes, Mr. S. Chaudhary. On what ground you have challenged this order at page 49?
my lord. This is a matter where the Bangladesh School has challenged the PhD on the ground that I have not taken due permission. Why?
No, no, we are not on the listing. On what ground you have challenged this order?
This is the ground. The director, the honorable Bhatia Court asked, therefore directing the director to pass a statement order based on a finding of a 2021 findings of the IS report matter. When it is stated by the IS officer that I cannot take a prior permission from the competent authority to pass to DAT. As such, thereafter, this order was passed by the director. Therefore, declaring my DAT to be invalid.
This one.
This one.
Where is the declaration?
Page 58.
In view of the above. What is view of the above?
There is not irregularity
Irregularity.
with the point principle of the school of so and so, 3 and season practice is yet telling us because for appointment of the principal now on the list of the principal list and submitted by
No,
the
as he got appointment on the basis of benefit of doubt due to misrepresentation of gradation list. This is another reason. Wherein the respondent was reflected to be B.Ed degree was miscommunicated. Who appears for the director? Mr. Chaudhary. Suppose a man obtains his B.Ed degree in an irregular manner. Okay. We have not taken permission. Quietly, he goes attend school, college somewhere, gets a degree. That may be a misconduct on the part of the employee. You may proceed on departmental proceeding. But will the degree become an invalid degree? Because degree is given by university. So, understand, so manner in obtaining the degree, will it make the degree itself invalid? What is the illegality or irregularity? He did not take permission, did not follow it. Please, Mr. Chaudhary, we always ask you not to interfere. You can also take your seat. Mr. Goswami is also taken his seat. When somebody else is taking, what you gain by saying? Do you ever expect that by you interrupting in between what Mr. B. Chaudhary is saying, what is going to be in your favor and discard Mr. Chaudhary? No, we are bound to hear Mr. Chaudhary. And you will have to allow us to. You did not. If you are not called for, did Mr. Chaudhary ask you to help him? No. Then why don't you allow a learned counsel to complete the submission, whatever he has? Yes, sir. No, we are trying to ask you. This is stated to be irregularity in the B.Ed degree. Irregularity is in the manner of obtaining the degree. Manner of obtaining a degree may be a misconduct. Consequence will be a disciplinary proceeding under the disciplinary and appeal rules. But will it render the degree itself to be invalid, not to be accepted?
Here, the issue was that both of the petitioner and the private respondent, they were awarded with regard to the B.Ed degree. And then in the earlier round of litigation,
no, whatever happened earlier,
Now, Lordship, the main issue was there that while attending the duty in school, the petitioner is simultaneously, he was projecting that simultaneously, he obtained the degree from the BEd school, which was having day shift. And the
Mr. Chaudhary, we understand everything. We are therefore asking you, going to the BEd school during the daytime by leaving aside his classes will be a misconduct.
yes, Lordship.
That may be a good reason even to terminate him if you want to. But will it render the degree otherwise, which is validly given by the university, to be invalid?
So, Lordship, that cannot be done because that has the.
So how- So
Senior in
I
university.
understand. So if the degree is not invalid, you are bound to take it into account. You cannot say, I'll not recognize your degree. Degree is to be given by the university. And the government of Assam has no jurisdiction not to recognize a degree, as long as it is a valid degree in paper. Manner of appointment, we are repeating, may be a misconduct. You can suspend him, you can terminate him, you can proceed against him.
Because of going by the present speaking order tenor, the director wants to take into account the manner of obtaining Lordship. And that,
You cannot really correlate that.
yes, Lordship, just to prove that was our submission because we cannot, the director cannot declare the degree to be invalid. There is the proper prescribed procedure. under
So,
the
but
university.
the director has done it now. He's again
That's
done
the
it.
tenor, Lordship.
So we set aside this one. If you feel that this man had done an illegal act during his service, take any disciplinary action, whatever you want to take.
Yes, Lordship.
But
Because
but you cannot de-recognize the degree.
it's a not proper appreciation of the direction given by the.
But anyway, you have already issued one show cause notice, I think.
That was with regard to not handing over the church. We went through this according to-
So you see, if you want to proceed against him, proceed against him. You suspend him and no demoted. But you cannot say that I will not take note of the degree.
Lordship, only the manner of
That manner cannot affect, or else you'll have to take up with the university that this man has obtained a degree in a fraudulent manner. Maybe he was attending my classes, so he did not attend BEd class, or then if the university withdraws, they can withdraw his degree.
university made that submission in the earlier round of litigation that they are going to declare it invalid on the basis of the NCT.
Understand? Maybe. So, but that only university can do it. Who appeals for the university? Is he a respondent here?
Yes.
Hmm.
Respondent number 6.
Ask Mr.
NCT
Pukul
is
to-
also there.
If the university takes a decision after giving him notice and all, we'll accept it. Or else what remains with you is to proceed against this man.
Director has not declared it invalid. Director says that we have obtained it supplement.
No, sorry. Director has said in view of the above, there has been irregularity in the BEd degree.
Irregular.
That's at page 50.
Irregular. Not very, not very.
So director has no jurisdiction to take that decision. Mr. Goswami, we understand. Either university takes note of the factual aspect and declare that this degree obtained in this manner is unacceptable. We withdraw it. Or the director takes action under the law of disciplinary to have conduct, because there was a misconduct. Director cannot say this degree was not accepted.
That is why the only selection the post of principal has been cancelled. And he was elected to prison post. And he
So now what is under challenge?
Now, this speaking order is under challenge.
Speaking order will hear it, but why there is a status quo?
May I point your
Just a minute. Why you are entitled to a status quo? What is your primary facie case for an interim order?
And it was page 26 madam, of the late petition madam. But the private respondent is saying that I had not taken a prior counsel. It's absolutely false.
Mr. S. Chaudhary, we are not deciding that.
Madam.
That will be decided by the university, they will be decided by the authority.
But the
We are,
I really have to challenge my.
Mr. S. Chaudhary, you have said page 50 order of the director,
My lord.
saying that your BA degree is irregular.
My lord.
Okay,
My lord.
we will decide it.
My lord.
But,
Director is trying.
but what primary
The
facie-
finding on the basis that for the IS officer, my lord, 2021, my lord. That is the question, my lord. And the IS has told me that I have not taken prior permission. But which is wrong because page 26 is clear that I'm taking the permission.
where is your permission?
Lordship, page 26 of the petition, my lord.
By whom?
By the, but IS, my lord.
You produce the records of the permission. Mr. S. Chaudhary, land counsel for the petitioner, states that the writ petitioner had taken due permission for undergoing the B.Ed course, which is claimed to have been certified by the principal of the school concerned. The records of the permission be produced before the court.
Because of this state,
May not.
but, my lord,
Interim order will be considered upon.
but the one thing is this, my lord, I'm holding this as on date, my lord. But if the status quo will be out, my lord,
You
they
can-
will charge. And one thing is that the practice is 59 years of age. Now, I am.
Mr. Chaudhary, if you are satisfied with the record, prima facie, we are going to stay. There is no status quo. Then he'll be again out. But till now, material is not available in your favor. Other than strenuously urging before the court, material is not available. Your only material you are hinging upon is that I had taken permission.
My lord.
So we want to see whether the permission exists or not. If it exists, we are going to bring back the order in a much better form, in the form of a stay order rather than a status quo. And if it is not there, you are.
My lord, let me put the charge.
We are clarifying. After hearing the Mr. S. Chaudhary, land counsel for the petitioner, it appears that the petitioner is disputing the conclusion arrived at in the impugned order dated 27/7/2023 by taking a stand that due permission had been granted to the writ petitioner to undergo the B.Ed course, and for the purpose, reliance is placed on a undated communication from the principal of Boroma Higher Secondary School.
You know, there's a thing, sir.
Please don't interfere, Mr. Chaudhary. Repeatedly, we are telling you one thing. And we expect to respect what the court wants.
My-
It's an annexure 1, wherein it is certified that the principal had requested the inspector school to offer the writ petitioner a permission. But the fact for determination would be whether the permission was actually granted or not. Respondents to produce the relevant records by which the permission may or may not have been granted to the petitioner. Further interim order will be considered on the next returnable date. For the present, we are not continuing with the order of status quo because that by itself is creating a confusion on the entire aspect. If prima facie case can be satisfied by the petition next returnable date, an appropriate interim order will be considered. Next week. 11. Okay, please come. 11. Come. make a proper case, we'll stay the entire thing, don't worry. But this cannot go on. But
We also want this, because if this status quo is creating havoc in the administration management. And both are
in fact, personally speaking, I'm not at all in favor of status quo orders. Find out if there is the entitlement interim order, grant the interim order in clear terms. If there is not entitlement, reject it. But little bit, neither here nor there, creates all kind of problems. So on 11th, we'll consider your interim case. And the complete record will be produced. Till then, word is also in other words called interim order. So other matter we have to continue, of course. Suppose he has taken permission or not taken permission. That will ultimately reflect whether he had done an irregularity or illegality while getting the degree. But again, we are back to square one. Degree, the director cannot recognize the degree or not take note of it. Suppose, see, interim order it didn't continue, saying that permission, irrespective of permission granted or not, suppose not granted also, what will be the situation? His degree was obtained in an irregular manner. So that the university will take it up, but not the department director, as long as the degree exists. So why should you not continue with the interim order? But one other aspect of the matter, if I heard Mr. Goswami correctly, he says he represents the vice principal. Now this is a case for in charge principal. When there is a vice principal, why the vice principal is not the in charge principal? I understand, but the reason is different. The reason is because of that degree, regular, irregular. We are putting you another question. If you see the rules, class 2 cadre comprises of vice principal, and then comes a postgraduate teacher. The petitioner is a postgraduate teacher. With or without BA degree, that's another question. Vice principal is one cadre higher. So when a higher cadre is available, why the higher cadre is ignored from being the in charge and it is given to a postgraduate teacher? I know your answer is in my order is different, but I am asking you why this principle is taken up at all. Only in the absence of a vice principal, the senior most or the most eligible postgraduate will be the in charge principal. But as long there is a vice principal, because the vice principal is one cadre above the teacher. So you make the in charge the vice principal. Mr. Chaudhary, what do you say? Suppose you are a regular principal, not in charge. Okay. Somebody is saying that they in charge.
In the present situation, the private respondent has to make the in charge principal who happens to be the vice principal.
But that again, we are back to the same question. Whether he had taken permission or not, suppose he had not taken permission also, how the degree will be affected? Degree, university can take it back. If they feel that for BA, you are required to attend regular classes, you are also a regular teacher somewhere else, you could not have attended, so we withdraw your degree. They can do it. But this decision cannot be taken by the director.
Also that, submitting lawsuit. Director cannot declare the event as long as it's in the existence.
As long it is there, it is. See, it is something like, suppose we pass a judgment. There is a big lacuna in the judgment. Or one document was not taken note of. It may be a case for review. But can it be a case for a government authority to say that the High Court did not take note of this document? So I say the judgment is irregular, I will not take note of it. You cannot do it. Course will be to go to the court and get it recalled. Similarly, if the Gauhati University had granted a degree, which was obtained in a little irregular manner, it will be only Gauhati University who will withdraw it. The director cannot say that I will not take note of that degree.
And this is also modern. Again, because also it's similar kind of cases also as part of the earlier.
Maybe that if that order was wrong, it doesn't mean you have to follow it again and again.
No, this is a conspiracy order passed to pass an order.
Anupama Devidasi is your matter. This is still pending.
No, sir, this was disposed of along with this. On the basis of these this order. Because this earlier selection was serious and mention of the court.
That page you referred to was relied on the earlier also, 9/2/2021. Not today, one is such a.
And inspector report of the
What happened to this petition?
district petition, on the basis of district petition, this order will consider
No, this petition is pending.
disposal.
No, WBC 337, is it pending or it is disposed of?
That was disposed of along with this petition. Hospital concept, that 337 also director for passing and speaking on. That order was passed by the director without taking into account the report provided from the inspector of school.
No, ultimately, no. What happened in this petition?
Along with this petition,
It is final order cases.
dispose of also.
337 2021.
This 30th. This 30th.
अच्छा, here it is. ऐसे बोलते हैं. Yes.
But this is the direction that is the director, the exercise.
Understand, but that's what it says. Suppose your conclusion is yes, this man did not have the permission. What will be the implication? Will the degree go, or it will be a case of misconduct? Degree may also go, but that will be the university. University plus the NCT. NCT may also have a view. NCT may also have a view that this degree is not valid. Because NCT for BA degrees is one of the governing authorities. They can also take a view that don't accept this degree. But the director cannot.
The director cannot declare that. Therefore, the submission also in the earlier round of division. It has to be the university. And university made a submission that they will do it because
Where is that submission?
not that good concept. In that if we and both NCT and
Where is Mr. Pupon? See, Mr. Pupon is available. Mr. Choduri, I think still will have to go against you for the time being. What we'll do is, we'll issue a direction to the university to take a definite decision by giving you a hearing whether the degree will be acceptable to the university or it will be not. If the university says it is acceptable, we'll allow you to continue as the principal. If the university says it is not acceptable, then this person will be a principal without a valid degree. Meaning thereby, the purpose for which the BA degree is required under the rules, that purpose will not be fulfilled. Although in paper you may have a BA degree. So let us do that. We'll ask the university to take a decision within 15 days or so. For 15 days, we are not passing any interim order. But otherwise, having gone into this much of detail, if I allow you to be the principal, at least from today onwards, we'll have a principal who may not have a valid BA degree. That cloud will not be removed. And if we do that, it will be a disservice to the students of their school, which are not concerned with whether the vice principal comes or what the director says. What about the students? Students will be subjected to a principal who may not have the appropriate degree. On that principle, we cannot allow.
In that case, since I'm a regular principal, I'm appointed regularly.
No, we'll stop you from being the principal for the time being. Till your degree is cleared by the Guwahati University, and we'll request the Guwahati University that we do it in the.
In the underlying litigation of the primary student state matter, they have not challenged the validity of the
Mr. Chaudhary, these ancillary aspects will not make a degree if otherwise valid to be invalid or otherwise invalid to be valid. Only thing is, it is the university who can take a decision. University, if necessary, in consultation with the NCT. Let them do it, complete it. Until the process is complete, let some other arrangement be made, not this petition.
And in that case, my lord, since I'm a regular principal and if there is a point of time, my lord, the vice principal joins it on the post, my lord.
No, we are not on the past facts. We are going to direct it from today onwards. We'll pass a comprehensive order.
In that case, let the ISP hold the, take the charge.
Why? IS also may not have BA. IS also may not be a competent person for being the principal.
The problem is this, my lord, so much person, my lord.
See, Mr. Chaudhary, your client, his degree is in a cloud.
My lord,
Cloud has to be removed.
my lord.
And after removing, either it is yes, a degree, or it is not a degree.
My lord.
till this cloud is removed, why should we allow a person with a degree with a cloud to continue as a principal?
There's two aspects of this matter. First of all, as Rossi rightly pointed, out, the voting university is the authority to justify whether I have a valid BEd degree or not. What are the norms for pursuing a BEd degree? First of all, when I
We don't know. It is what university will decide all those. Yes, where is Mr. Kumar? PJ Kumar.
there has to be 80% attendance of the classes.
Mr. Chaudhary, how can a report go into those questions? It will be university they will go into. You say everything you have to say to the university.
But now we are finding out the two aspects. First of all, the validity of the BEd degree and whether I have taken prior permission or not. If the Guwahati University says
Mr.
that-
Chaudhary, you say everything to the Guwahati University. As far as the court is concerned, as on today, the BEd degree is in a cloud. It may be a valid degree, it may not be a valid degree. When there is a question mark on the validity of the BEd degree, we feel a person having such a degree should not be allowed to be the principal for the time being. This is on the extent where the court is going, not beyond that. So all your submissions saying that it is valid, you make it before the authority.
I'm not saying my lord as on date. that-
Okay, we are unable to accept it what you were saying. Where is Mr. Fupan? Can we have him? Mr. Fupan. Ultimately, whether this degree is valid or not, which is obtained in this circumstance, it is the university will have to take a decision. We can't conceive a situation where a director will take a decision. You take the decision within a limited period. Give notice to the petitioner also. Give him all the hearing he wants, whatever justification he wants to make. And you also do it in consultation with the NCT. Because these are degrees of a different nature. It is not just a regular discipline to be maintained that you have to attend the classes. BEd degree, some specialized trainings, etc., are given in the BEd course for a person to be qualified as a BEd teacher, to have the qualification of BEd. If you have not attended the classes, maybe the training was incomplete. Examination is ultimately those theoretical questions that are put. You may have answered those, but the appropriate training is not be complete because this is a theoretical plus practical course. It's both. So you take a decision, find out whether this person had actually attended classes or not. All for the records of the institute. Find out whether the manner in which he attended classes do make him eligible to appear in the BEd examination. If it does not, take a decision that his valid degree is not valid. If you feel that no, everything is acceptable, take a decision that degree is valid. Okay. Give him notice. Take the views of the NCT also, because ultimately they are the governing body regarding BEd degrees. It's not only the university. Punjab, you take a decision, tell us. If his degree is valid, we'll allow him to continue as a principal. If his degree is not valid, definitely we cannot ask a person without a valid degree to be a principal of a college. You are having difficulty in taking a decision. We'll provide it and we'll make LCT a respondent and ask them to cooperate with you. LCT will be Ayala. Can you get Mr. Ayala? He is there already. And you wait for some time to get it.
Just a small issue, my lord. Then on the last repetition, what the colleges stated, they are on the attendance register. They are,
That is the headache of the university, the NCT, not our headache. Because BEd degree is not only a piece of paper, it has a purpose. and the students are subjected to that purpose. And our error loss and balance of convenience is from the point of view of the students, not between the petitioner and the private respondent.
Another thing is this, madam.
I think we are given enough time. Many others are waiting for that. Or else we discontinue the interim and fix for some hearing on some other day.
The question is very narrow, madam. As a regular principal,
We are still arguing. Vacate the interim order, response to it.
I'm just trying to.
We have not asked you anything beyond that. See, we have to attend to everybody, not just to one person who is trying to become a principal. And that has no public interest, in fact. And only public interest is whether the students are getting a duly qualified principal or not. That's the only public interest. Heard Mr. S. Chaudhary, the counsel for petitioner, Mr. B. Chaudhary for the respondents in the BTC, Mr. P.J. Fugan for the authorities under the Guwahati University. Okay, Mr. S.K. Goswami for the respondent number. Education, you are referring? Secondary education. Mr. U. Sharma for the authorities under the secondary education. And Mr. S.K. Goswami for respondent number 10, Anupama Devi. The petitioner Bharat Chandra Talukdar, otherwise a postgraduate teacher, who was a postgraduate teacher in the Burma Higher Secondary School, had participated in the selection process for appointment of a regular principal. Mr. Alam. Mr. Alam, we want you. One question has arisen that a teacher who was doing regular day classes also attended a day class B.Ed institute at a different place, and he obtained his B.Ed degree. Government is saying it is not regular, but as a degree had already been obtained from the Guwahati University, under, I think also NCT also has some control over B.Ed degrees. We are viewed that only the Guwahati University can take a decision whether this degree is valid or not. Government cannot take. So we are directing the Guwahati University to issue notice also to the petitioner and take a final decision that in the circumstance of this matter, this degree is a valid degree under the law or not. NCT has a major role. NCT authorities has to closely cooperate with the Guwahati University in arriving at the conclusion. That for that purpose. Means nowadays things can be done in virtual mode also. Your officers and Guwahati University can confer with each other also if necessary by taking that purpose.
The petitioner Sancho, who was a teacher in the Burma Higher Secondary School, had participated in the selection process for appointment of the regular teacher.
Principal, and accordingly, upon being selected, he is also appointed. The participation of the writ petitioner Bharat Chandra Talukdar was assailed by the respondent Anupama Devi in an earlier writ petition, being WPC. Three seven seven. WPC 337 that as the writ petitioner was a regular teacher in a day school and had also undertaken the B.Ed course in a day course in another institute which is located in some other place, the degree itself would be vitiated. The said writ petition was given a consideration along with two other writ petitions, WBC 8277/2022, which was by Anupama Devi, assailing the order of appointment of the writ petitioner, and WBC 1026/2023, assailing a later order dated 18/9/2021 of the Director of Education, BTC Pokraja. The said three writ petitions resulted in the order dated 26/6/2023, by which the Director of Education, BTC, was required to take a fresh decision on the matter. By taking note of the factual aspect, SDP College of Teacher Education, TU, from where the petitioner had undertaken a B.Ed course, does not have any evening shift to impart a B.Ed degree, and therefore, under what circumstance it was possible for the writ petitioner to undertake the B.Ed course by attending day classes in the Boroma High School, which is located in another place. Consequent thereof, the order dated 27/7/2023 had been passed by the Director of Education, BTC Pokraja. The director takes notes of the attending facts and circumstances, and in the ultimate paragraph of the said order was of the view that the B.Ed degree obtained by the petitioner Bharat Chandra Talukdar is irregular. Accordingly, by the same order, the respondent number 10, Anupama Devi, who is otherwise the Vice Principal of Boroma Higher Secondary School, was temporarily allowed to discharge the duties of the principal. The order dated 27/7/2023 is assailed by the writ petitioner by taking a stand that it is incorrect depiction of fact that the writ petitioner Bharat Chandra Talukdar had not obtained permission for undergoing the B.Ed course. But a question would arise that even if the writ petitioner Bharat Chandra Talukdar had obtained necessary permission to undergo the B.Ed course, whether it is the Director of Education, BTC, would have the jurisdiction to take a call on the acceptability of the B.Ed degree of the petitioner. The B.Ed degree had been obtained from the Guwahati University, and the NCET is the appropriate regulatory authority under the law as regards the acceptability and validity of any B.Ed degree. In the circumstance, we are of the view that there is a requirement of the Guwahati University to take a final decision on the acceptability and validity of the B.Ed degree of the writ petitioner Bharat Chandra Talukdar as to whether the manner and circumstance in which the degree was obtained would be acceptable in law to be declared to be a valid degree. in doing so, as the NCT is the appropriate regulatory authority regarding the procedures and requirements of obtaining a BA degree, the Guwahati University, while taking a final decision, shall do it in consultation with the appropriate authorities in the NCT. Accordingly, the authorities in the NCT is also directed to cooperate completely with the Guwahati University in arriving at the decision. As certain factual as certain contradictory factual situations are also sought to be relied upon by the writ petition of Bharat Chandra Talukdar, the Guwahati University, while taking a final decision, shall give an opportunity of hearing to the writ petition of Bharat Chandra Talukdar to explain his case. The Guwahati University shall also call for the complete records of the SDP from where the petitioner had undertaken the BA course, and which shall also be taken note of by the authorities in the NCET, and their views be also formally informed to the Guwahati University whether the manner in which the BA course was undertaken by the petitioner, whether it can lead to a valid BA degree. Upon doing the needful, a final decision be taken by the Guwahati University and the same be informed to the court. How much time? It won't take a very long time. 1 month? 1 month. The entire process of conducting the hearing by the Guwahati University in consultation with the NCET by giving official hearing to the petitioner and to arrive at a final decision be done within a period of 1 month from today. In the circumstance, on the question of interim order in the present writ petition, it is noticed that if an interim order is passed against the order dated 27/7/2023 of the Director Education BTC, it will be the writ petitioner of Bharat Chandra Talukdar who will discharge the duties of principal of Boroma Higher Secondary School. Having a valid BA degree is one of the essential requirements of being a principal of a higher secondary school. And when the degree of the writ petition of Bharat Chandra Talukdar itself is in a cloud, that is, it may either be a valid degree or it may be an invalid degree. We have to view that the balance and convenience and the irreparable loss in the circumstance would require that Bharat Chandra Talukdar be not allowed to discharge the duties of a principal till the decision is taken by the Guwahati University. And in the meantime, the respondents may allow any other eligible person under the law to discharge the functions of the principal. If in the event it happens that the degree would not be a valid degree, and if the writ petitioner is allowed to continue as the principal, it will be the students of the institute who will suffer the most, as because a person who would be otherwise ineligible in law would be the principal of the college. It is taking note of the aforesaid circumstance that the balance of convenience and irreparable loss in the present case is being determined. List on. Everything clear? You go and prove it, say whatever you say, whichever you do. Sorry. No, actually you see, once you interrupt, my thinking goes off. That continuity is very difficult to get back. So what we prefer is, if anything is to be done, do it at the end of the audit. We'll always correct it if you say something. Yes, thank you. After 1 month, we'll list it once again. After 1 month. You may issue notice and you also cooperate with the administrator. A copy of the order be made available to Mr. S. Chaudhary, line counsel for the petitioner, Mr. I. Alam for the NCT, and Mr. P. Jaffar for the Guwahati University, as well as to Mr. B. Chaudhary for the director. Yes. I think that's good.
Filing 23-24.
Yes, so we wanted Mr. R.M. Das for what department it is named now? Social Justice. We want him. Do you appear for the department?
I detail of the
No behalf. Do you appear for the department or you don't appear for the department?
I don't know, Lordship, he is not available today due to some personal reasons.
What personal reasons?
Others,
Mother is it?
but I can complain.
Does the department have any other council or there is only one council? Then ask the secretary to remain present. We'll directly interact with the secretary. No, we don't want to disturb Mr. Das because his mother is ill. Let the secretary of the department remain present. We'll directly interact with the secretary. I think it should not cause any prejudice. We should not disturb a council whose mother is ill. But at the same time, there are some urgencies in these matters involving a number of people.
The petition has to be corrected also.
No, you don't go on those technical objections.
But
See, Mr. Young Counsel, we are not, don't require the secretary for any reprimanding or anything like that. We want to carry forward the court proceedings, that's all. Normally, it is the litigants who are the person before the court. Lawyer is only a power of attorney holder to represent. If the lawyer is having difficulty, let the original litigant come. This is what we are saying.
they are social justice, not party.
May not be party, we want him. Forget about your technical objections. And there's a purpose why we need him.
I can complain.
With whom?
Sir, I am not.
So it should not be disturbed because he is having personal inconvenience. Why be disturbed? But they are having difficulties, the schools. Not only one school, I think many people are having difficulty because one particular decision is not taken for the last 3 years almost. So we want the secretary to take the decision. That's all. Decide either way, whichever way you decide. Who secretary will come? Mr. Das. But we don't want to disturb Mr. Das. It will be improper when he's having so severe a personal inconvenience, we recover him to remain present. We don't want to do that also. No, we don't want to disturb him. We are very clear. We don't want to disturb Mr. Das at all. You do it. What's your name, please? Mr. C. Sharma is present before the court on behalf of the Social Justice Department. In the absence of Mr. R.M. Das, the standing counsel for the department. The Social Justice Department is entrusted with the responsibility of forming the, what committee it is called?
Some state level, caste scrutiny.
Assam State Level Caste Scrutiny Committee. We have been informed that on a particular question as to whether certain persons do belong to the tea garden stroke ex tea garden community in order to be categorized as OBC. No decision had been taken by the committee for almost 3 years, and this has resulted in great inconvenience to many of the students as well as to the education institutions for admitting the particular category of OBC students. And as such, we are of the view that there is that an urgent situation had arisen where a final decision should be taken. Mr. C. Sharma, by conferring with the Secretary to the Government of Assam in the Social Justice Department, shall inform the court as to when the committee will be constituted and within how much time the final decision would be taken. List on list on 7th, you tell us. No, we don't need you. We only need the time. We have already heard you. Let us constitute and take this decision. There are some people with surname Chauhan. Chauhan and Singh, who are holding OBC certificates. OBC certificate that they are belong to the tea garden community. And this has been challenged by many people. And some of them say that they are Hindi-speaking people from some place, they cannot be tea garden. This question requires to be determined.
There is another problem here. There is another problem in that particular cigarette. The next cigarette.
I know. We use the expression tea garden, next tea garden.
Now, who is the ex-cigarette? Suppose a candidate's ancestors, they were working in a tea garden. Whether they will be considered as ex-cigarette or labor or not, that issue has to be also determined better.
See, Mr. Bora, this is a categorization by community or it is a categorization by occupation. Suppose today you go and do the tea garden work for a month and you come out. Will you become the ex-tea garden labor community? That's why the word is community, not the occupation. Suppose this man may have discharged the function of a tea garden labor for a given period of time. Will it make them a ex-tea garden community? That's a question. I think that's a question. And ex-tea garden community, presently, whether even if they are not tea garden laborers, still they belong to the community. On the other hand, somebody doing the work of tea garden also may not belong to that community. Let the government take a decision. Mr. Sharma, come back. Sorry. We are copies. Doesn't matter. We'll only want to take it forward. That's all. We'll hear you later on. Inform us the constitution of the committee and how much time will you take to decide. Deputy Commissioner, not the final authority.
Whereby it has now been specified that it is not only the signature, it has to be obtained from the online web portal and to be verified by the
No, we are not concerned with that. First, you clear the issue whether you belong to the community or not.
Now the deputy commissioner.
Mr. Bora, question is not certificate. Question is whether this category of people do belong to that community or not. Let them take that decision first. Once the decision is in their favor, then the next stage will come. will issue the certificate and how to issue the certificate.
That is why the decision that can only be taken when there is a dispute from the responsible producer. I don't belong to that.
Mr. Bora, you don't have to worry. That's not your headache, how they take a decision. You just go and participate with them. Corporate, that's all. Don't try to delay this matter by all this.
39.
Seventh will have the views of the department. Yes, Mr. Amateur. 2015 matter. 8 years have gone by. Why? Anyway. What is the grievance? To correct the percentage of marks. Just a minute. The director has to correct the percentage of marks as per marks and place her in the 10th position in the merit list and appoint her. Are you working? No.
No. I will working somewhere else. I graduate somewhere else. But I am working subjects.
So now, if your merit position is corrected, it is the petitioner who will be entitled to appointment.
Because 1 to 9 have already
So,
been appointed.
What about the 10th post? No one is appointed. Post is vacant. Is the post vacant? In the selection process, how many posts were advertised? Only one.
One post of the particular done side, the next is one.
So so who is appointed? In that selection, who is appointed? Anybody appointed?
I don't think at that point of time, nobody was appointed at the point of time. See what I was there. On this one.
After that, understand, stay order, no one appointed. What is the position as on today? For whom do you appear, Mr. Dotto?
I'm for responding for the principal secretary, the people
Of the school authorities. Who is working in that post now? I think that will be a necessary information. Who is working presently? If no one is working, if it is still vacant, we can hear it. And if somebody is working, we have to see what happened. But there is an interim order, you say. Then what happened to the interim order? Was the interim order restored? Then, if they have appointed somebody in the meantime, what will happen? When was it dismissed? In which year? 18. So after 18, if there is no interim order, they may have appointed somebody. How do you know? By this writ petition, the petitioner claims that in the selection process, pursuant to an advertisement dated 10/6/2014 of the Pithubor Girls Higher Secondary School, Kwang, Dibrugarh, the petitioner participated for the post of subject teacher in political science. The petitioner raised a grievance that in the merit list that was prepared by the selection committee, the position of the petitioner was shown in the 11th position. But whereas, as per the calculation put forward by the petitioner, her place in the order of merit ought to have been in the 10th position, and accordingly claims that she would have been entitled to an appointment. When notice was issued, when notice was issued on 25/5/2015, there was an interim order that school authorities, with respondents number 4 and 5, shall not fill up the post of subject teacher of political science in the political science. But it is stated that by a later order dated 11/12/18, the writ petition stood dismissed for non-prosecution, and accordingly the interim order was also vacated. Later on, by which order it was restored? Later on, by the order dated 15/7/2019 in IS Civil 1970/2019, the writ petition was restored to file, but there is no indication that the interim order was continued again. In the circumstance, the school authorities to inform the court as to whether the post of subject of political science, which was advertised by the advertisement dated so and so, is still vacant, or it has been filled up in the meantime by some other means. List on so and so for the information.
Item 40.
Regarding the appointment of the advertisement was made on 5. The advertisement is the importance have been given to 10 candidates for any post of by awarding marks for passing the unit to 6 students. Diploma in agriculture.
So, what is the dispute that they were selected, not appointed?
I was not selected.
Not selected.
Appointed also. So in 2005 advertisement of this, the authority was quite silent regarding appointment. And in 2012, 2014, the appointments were made by the authority. But the criteria, the importance given regarding pre-service training for 2 years. I had the training, but my
So 2005 selection made in 2014.
2014.
And their issue arises whether preference should be given to some training. Petitioner had the training or did not have the training?
I had the training, but the activity that those have been filed under the additional activity that has also been filed, but there is nothing more that is left under the other. That criteria, the criteria was considered as
So now somebody is already appointed.
already appointed, but my.
How many petitioners are here? One petitioner. Suppose we go in your favor, what will happen?
If I have.
No, suppose we hold everything in your favor. What will be the result? Appointment.
Yes,
are any posts available? If post is not available, where will we order an appointment? Definitely, we can't ask that take out a post from 2023 and give it, because the new generation will be affected. And it's a claim of 2005, 20 years. I know it is not your fault. It is a grave illegality. But what relief can we grant? Even if it is available, how can we direct? Because the next generation man will say that this is my post, not a post for a man who applied 20 years back. Then that is why we are asking you, what do you say? Yes, Madam Bora, for whom will you appear? It's a BTC. BTC matter. No. His case is that there is a requirement to take note of some pre-service training, which will have some due weightage, but the petitioner was not given that weightage. Had you given the weightage, it is he who would have been selected. I think this is his case. Did you give the weightage or you did not give the weightage? No. Specific question raised is, under the procedure, pre-service training has to be given some weightage. He says, in my case, I have the training but not given. Did you give the weightage or not? Mr. D. Chaudhary, then counsel for the petitioner, has raised the contention that under the procedure adopted for making the selection, there was a requirement to give due weightage to the pre-service training that the candidates may have. The petitioner contends that while subjecting the petitioner to the selection process, although he had the pre-service training, due weightage was not given, and therefore he was illegally deprived from being selected and appointed. The respondents to provide the specific information as to whether the pre-service training of the petitioner was given due consideration and weightage when the selection process was made in respect of the petitioner. This also for the information. But ultimately, what will happen? Think about it. 60 years. If he is 60 years, he'll retire before he is appointed.
Not 60 years, but
Item 41.
For appointment to the post of headmaster. Sorry. Infrastructure. Sorry. Notional, how can it be given? No, notional is not given that way. The concept of notional benefit is not that. Pension you may claim. Just who appears for the. Sorry. After. what Mr. Khan submits, that this is a claim for being appointed as a headmaster. But the man has retired from service in the meantime. He says the issue is still open because if I was illegally deprived, I should be given pension at the rate of a headmaster. That's his claim. So you answered whether he was deprived or not deprived. If he dismiss the matter, it's okay. If he allow it, what will happen? Hmm? Good.
Petitioners around science, the teachers, my God. Sorry.
42, Sankar Patwari.
Yes, Sankar. The matter relates to selection of a principal of the college.
Started with some other case.
Madam,
Started with some other case.
I think 43 days was. Madam, there will also take some time. to dispose of it.
But today I have a division bench.
That's right.
You can fix on some other day.
Some of it.
You can do it for it.
Or that is
As paid for this topic.
Request 20%.
will be 20.
I think you have to take up that medical admission matter also.
There's no motion of that.
Nation will do it. Motion to take it. No.
Item 43 for motion.
Yes. And the petitioners are all actually, my lord, the assistant teacher science. Knows under the answer services are now operating the concept of CS, cluster resource center. The concept to my lord, appointed coordinator.
Appointed.
CRC.
They said
Coordinator.
coordinator.
Idea is to basically to augment the effort of the teaching. There was a particular advertisement, pursuant to which we participated in this selection process, and we are all selected. I just draw your lordship's kind attention to the my lord and his man. Lordship will kindly come to page 40, my lord. And I'll have your lordship's kind attention to page 41. Basic qualification for application for cluster resource center coordinator. Please come to my lord and somewhere in the middle. A teacher from single double school is not eligible to apply. Because my lord, if in a school particular school there is either singular and double teacher, then my lord, the whole thing will be distributed. Therefore, they cannot apply. This is a bearing, my lord. That's why I have brought your lordship.
Cluster resource center coordinator. What does it?
Basically, augment the my lord teaching effort.
No, he remains a teacher or he does not remain a teacher.
It's a teacher, but then my lord.
Does he go to class or he sits
No,
in somewhere
he-
else?
Some sort of a, my lord, he helps the teaching effort along with the other teachers.
Means coordinates.
For
Coordinates between different teachers. So he's a
in a
man.
cluster.
He's a man who is a little higher in
Slightly
the
above
the teachers.
Slightly, slightly. So my lord, when we apply, the advertisement itself says, if a school from which where I work, if it's a single or double, then I cannot apply. Then my lord will kindly come to subsequent advertisement at page 47. The advertisement which I referred, that is of 2013.
Earlier
Now-
advertisement.
Yes, 2013. And now at page 14 and 78, my lord, it's an advertisement of 12/5/23. Please come to page 49 on top, serial number 4. Single, that is Hindi, the science, Hindi, classical, Arabic teacher will not be eligible. Now, my lord, what has happened? Now, an order has been, by this advertisement at page 48, a new advertisement has been issued. Now, this is the Niche according to me, my lord, 12/5/23.
Page number
page number 48.
No, 48 we have read it,
Yes.
that
No,
the serial,
I have drawn the attention to page 49. Please come to 48, my lord.
Huh.
Applications are invited from assistant teacher, both contractual and regular, interested to work for temporary attachment of cluster resource center, who fulfill the eligibility criteria mentioned below. Now, pursuant to this, my lord, now they seek to make selection. Now, my lord, will kindly come to page 55. This is the ordering. In due consideration of shortage of science and mathematics teachers in schools causing serious prejudice to the student, Government of Assam by letter dated 12/5/6/23 issued directions to withdraw attachment of all science and mathematics teachers presently working as cluster resource center coordinator in persons where Ranaditya Kumar Burma, that's the petitioner number 1, presently addressed as CLCC, Saprakata cluster is thereby released from attachment with effect from 8/8/23 and reverted back to his original place of posting as a teacher in Mysore. Actually, my lord, it should be not 8/8, it should be 8/9 because the order itself is of 9/8 and next page they clarify.
okay, right.
Yes, it should be 8/9.
8/9/2023.
8/9/2023.
Also, with effect from.
Yes, with effect from that date, my lord, the petitioner will be amongst others will be stand released.
So this is against Ranaditya Burma. He is the
Petitioner number 1.
only one issued or many others?
Very well. We are 55 and 4
All the science and
Yes,
mathematics.
yes. Now, my lord, will kindly come to paragraph 9 at page 24. In fact, also may kindly come to page 25. And you see, my lord, the number of science and mathematics teachers presently working in the parent schools of the present petitioners are given here below. For example, this Burma petitioner number of 20 works, there are 5
Five,
science
five teachers.
teachers. Similarly, the whole intercept of all the 54 were given. Now, my submission is by 12/5/23, they have issued an advertisement for fresh selection. Now, what they would like to do, now they would like to make fresh selection and put them in the cluster resource center. Now, at end of the day, when we applied, there was a restriction. Single double teachers who cannot apply. Therefore, my lord, where is the question of what background we are reverting? We have very good grounds to revert to that one other ground because my substantive appointment is an assistant teacher. But this ground cannot be said legal strictly for the simple reason. Apart from the chart, my lord, already when we applied those conditions were there. So that is my lord, there.
That a double single cannot.
Yes.
So meaning thereby apprehending that there may be a requirement of teacher in future. Single and double is not allowed. We'll take only from having
School having more than single and double.
the modern single and double.
Therefore, the reason cited in the order that there are shortage, that's not correct. That's my humble submission. So therefore, that means they want to replace one set or another by another, something like that. So therefore, in my humble submission, my
And
lord,
for how long is these appointments made?
so in fact, we are there from 2013. For the
No,
last-
and then normally how long it is made for?
There is no outer time.
No other time.
No outer. It's a fact, my lord, we are enjoying certain more status than one grade as an assistant teacher. As a cluster.
Did the people teach mathematics and science in
Yes.
between?
Not wrong.
They kept on teaching also.
Yes, in that cluster, I will do everything. Teaching, managing everything.
No. Only thing you did not teach in Bapuji school.
Ah,
You
other school, yes.
you taught some in some other school.
I am primarily a teacher.
Yes, Mr. Naik. What is this? So Naik, give me.
Yes, I've given it.
So there's a wholesome decision taken that science and maths will not, we are withdrawing.
Madam, I only have good submission is-
Because they feel
I'm
that
not disputing.
that in general, we are having shortage of science and maths teacher. So we take them out from this responsibility.
Yes, my lord, they have issued their advertisement on 12/5/20.
But there also will clarify those science and maths teacher.
That is an advertisement of today. These decision was taken in the month of.
So,
We are going to issue horizontal.
So have you withdrawn the other advertisement?
We are going to issue a horizontal separate that advertisement is concerned.
So, madam,
You
since-
do one thing, you bring the corrigendum, bring it next week.
Yes,
Till next week, at least give him
Yes,
some ready for 7 days.
That advertisement, that is future advertisement for future adjustment.
Understand? There also you give the corrigendum that no science and maths.
Yes, we are going to some this.
Then after that, we'll consider
Yes.
next week.
No, in this case, consider kindly say base 55,000, the period.
See, Mr. Nayak, anyway, release from attachment with effect from 8/9. As on today, we are on 1/9.
Yes.
7 days is still more. We are listing it after 7 days. Because whatever status quo you're passing, it is anyway, it is there.
so till 8/9, they will not disturb, but the loss will have to matter.
No, that is the order of the loss of but because this is an adjustment for 1 year. And so in the contract, consider base 7. Base 7. Here, this is petitioner number
I
1.
understand.
Consider kindly see paragraph 1. He is working from 2013. And this is a period for 1 year, it is extended.
But this will go against you. Because if it is for 1 year, you did not, it is, there's an implied modification of the contract by having allowed him to continue for 10 years.
Clause 6.
This will not help you, the other one may. So you bring the decision that henceforth science and maths will be absolutely out. Take note of that. This is a decision that existing ones will be brought out. But as there is also an impending advertisement, which may include science and maths, bring in a corrigendum that we are taking out science and maths even in future. And possibly then they will not have any.
But there, this notification will be effective from 8/9.
Understand?
So we are still having 8 days.
So maintain that status quo.
Otherwise also it is.
I heard
Order is there.
I heard Mr. Ken Chaudhary, last I also heard Mr. P. Naik and council for respondents in the homographic also. And also Mr. E. Bhavan for the education department. The petitioners were all appointed as, were attached as Cluster Resource Center Coordinator pursuant to an advertisement.
Advertisements were different.
Amongst which one such advertisement is of the year
2012, my lord.
2012, available at page 40 annexure A to the writ petition, wherein there is a clause that a teacher from a single stroke double teacher school would not be eligible for such attachment. In the meantime, the respondents have issued another advertisement have issued another advertisement dated 12/5/2023, wherein a condition had been brought in that single science, Hindi, classical, Arabic, Sanskrit teacher of a school will not be eligible for such for the attachment. In the circumstance, the order impugned dated 9/8/2023 was passed by the Executive Director of Homogra Hikka that in consideration of the shortage of science and mathematics teachers in the schools, which had caused serious prejudice to the students, the government of Assam intends to withdraw attachment of all science and mathematics teachers presently working as cluster resource science coordinator. And accordingly, the writ petitioner number 1, Ranaditya Kumar Borman, had been released from the attachment with effect from 8/9/2023 for being reverted back to his original place of posting as teacher in the Bapuji High School of Bongaigaon district. Mr. P. Nayak, Land Counsel for the Homogra Hika, has produced a communication dated 12/6/2023 from the Chief Secretary to the Government of Assam, addressed to the Mission Director, Homogra Hika Ovijan Mission, wherein which contains the information that as per the discussion in the cabinet regarding engagement of science and mathematics teachers as cluster research coordinator, the absence and shortage of science and mathematics teachers in the schools had seriously hampered the teaching of science and mathematics subjects, and therefore there is a decision that henceforth science and mathematics teachers may not be engaged as cluster research coordinator in any coordinator. It is contended that because of the said decision, the order impugned dated 9/8/2023 had been passed, withdrawing the writ petitioners from their engagement as cluster resource coordinators. The communication dated 12/6/2023 appears to be a general decision taken by the cabinet not to engage science and mathematics teachers as cluster resource persons. But if the later advertisement dated 12/5/2023 is taken note of, it is only the single schools, it is only the single science teacher schools. It is only the teachers of the single science teacher school will be ineligible to participate, meaning thereby that other science and teachers may participate. In view of the above, Mr. P. Nayak submits that a corrigendum would be effected to the advertisement dated so and so, whereby it would be specifically put that no science and mathematics teachers would be engaged as cluster resource person. In view of the above, list on so and so for any such corrigendum, if intended to be issued, list on 27 or 8.
16/6
No, till the next return date, a status could be maintained.
One way of handling this notification by issuing it for a corrigendum, or the authority may also go for.
Mr. Nayak clarifies that instead of issuing a corrigendum, the method of withdrawing the advertisement and issuing a fresh advertisement may also be resorted to. We have taken note of the said submission.
44.
Mr. We'll have to, I think, take on some other day because I have to attend the other bench. And that medical matter still remains. I think someone there. Jadi gimana itu maksud?
Itu 44 atau 45
Tapi untuk lagi one itu itu. It's a motion. Any urgency?
So this can be reported.
If you have urgency,
They have initiated the school selection process for the masters. Pensioners are going to their research in working in English school, they are suddenly working with the high school. Now they are not being considered master.
I think in the morning we took up that matter. I think same nature. That one and Soikya and not different. Do you need any interim order? No. On that we'll have to decide. Mr. Saikya, that we'll have to decide depending on the. What is the last date for submission of application? Sorry,
Nothing is there.
it has yet to take place. List again in the next page. Next page. And if there is any last date, we'll ask you to tentatively take it and then we'll decide next week.
45.
That's one.
Lordship tackling together with those two.
That's along with item 20.
3975 and 3976.
That OBC. OBC.
Yes,
7.
777.
You continue. We are not disturbing your provision.
But we are not allowed to participate class more than 5 days.
See, if a provisionally admitted, allow them to attend class also.
That is happening, but the only problem is the financial burden on the, because once they take the residential of renters, then the entire financial burden comes on.
I'd say it's a residential.
You're fully the reason why people are so avid for admissions and NTS in the JLBs is because of the fact that they are completely fully residential schools. My finance 100%.
But we have already, no. What will happen if the decision is in their favor? They'll miss classes for, do one thing. What is the expense? No, what is the expense for a month for a student?
30,000 rupees per month.
Pay 30,000, attend your class.
That-
Suppose you are regularly admitted, you will have to pay the 30,000.
No,
Then how
Government
much?
of India pays the entire finance. They, not a single penny is taken from the children. That is why it is run by the center. The
Okay,
entire
it's-
scheme is run by the center.
Okay.
But these are two petitioners. I will just take instructions on
No,
seven.
what we are saying is, suppose it goes in their favor.
In fact, the petitioner number.
Every inquiry,
He
every
submitted a plan, right, sir?
every inquiry has two possibilities,
Yes, sir.
either this way or that way. Suppose it goes, they will lose out that 1 month.
That's right. I'll find out. Because we have specifically instructed that in terms of the interim order, they should be allowed to, give provision.
So when provisional means
They should be allowed.
all the
I'll instruct them.
all the attending circumstances connected to provisional admission.
We think it was 2020 onwards, 6 or 7 children who have ultimately been declared invalid certificates of OBC, but they continue to function because of, they continue to study with us. Because of that, state level scrutiny committee has not
No,
decided.
no, this will take care of. This issue will take care.
I instruct them.
As long as it is before me, you don't worry. You'll get the answer. Approved.
Yes.
Petitioner number 2 has chairman.
Has been approved.
Or
and
it's a different issue.
No, great, but he has a valid, he's a fatwa. He has a valid OBC, T-type certificate. Which has been duly approved by the deputy commissioner, is on the online web portal. His name has been duly verified.
No. I'm sorry. We are not on the certificates. What we are trying to find out is whether these people are entitled to that certificate or not.
Yes. So that, there's a central list of OBCs, and there are tribes which have been, and as per the basic.
So now the petition to what all will be passed? Nothing different.
Nothing different. Right now, we will leave it the way that it is. Nothing.
Then we'll take
Let
it.
it be tagged by those two petitions.
Okay.
And we'll cross them.
No, we are short of time for the other.
Item 3.
If you're there.
Just the medical admission. Did you find out any candidate? Huh. Did you find out any candidate who was entitled to an unreserved seat by virtue of his choice of institution, but opted for another institute, taking advantage of the EWS, and that EWS will now come to the original institution? Where is Mr. Gogoi gone? What is it? Mr. Gogoi, Mr. Ganguly is expressing difficulty in understanding the list given to him. What basically we want is whether any candidate who is otherwise entitled to an unreserved seat by virtue of his choice of institution had opted for another institution under the EWS quota, which will require the proviso to be invoked, and EW from that institute be now brought to the original institute of his choice. Is there any such candidate? I think you'll need time to understand. We are listing it on 7th. In the meantime, 6 days.
Yes, I have given him a chart. You can go through it.
You also go through it.
Basically, because the petition as of now is that he is raising a query. We are trying to explain it to him. Instead of that, he must point out that these are the arbitrary candidates of the EWS who have been admitted.
Mr. Gogoi, ordinarily you are right. But ordinarily you are right. But he is not privy to this information. It is only you who have this information.
So that we can not
Normally you are right.
specific, we will find it later.
Perform.
On 7, let him point out
Mr. Gogoi,
and give us one.
then allow this man access to all your computers and records and everything.
No, I'm not on that. No, I just.
5 minutes we don't have. Other bench is equally important. We don't have 5 minutes. List on 7. So we feel that your authorities are in a better position to do, because you will have all the records with you. There are how many candidates? Approximately 500.
500.
Just a minute. You engage some of your subordinate staff to scrutinize the application of all the 500 or whatever number of candidates it is. Find out if there is any candidate whose first choice institute, he would have been entitled to an unreserved seat, but at the time of counseling, he opted for another institute under the EWS. If you find, you tell us. And I think it will be easier for you because you'll having all the application and all the information with you. Now you have 5 days to do it. Do it. Then do it.
Yes, conversion is formal.
No, not only conversion. Candidate who is by choice of his institute entitled to an unreserved seat, but had opted for another institute under EWS.
Page 60, just for a moment, just page 60.
What does it say?
This says, my lord, this is serial number 73. Mustaq Ahmed, he is the EWS candidate. He was considered under unreserved, but he opted for EWS. So he was granted a seat in TMC. And my lord,
So now,
he was converted to unreserved.
GNC. So now, no, initially where he was given?
Initially, my lord, no, my lord, considering his choice of subject matter, that we see from the chart, probably it was not there.
No. Find out, take out the application of this man, find out his first choice of institute.
Yes.
Okay, because we have to give due importance to Rule 8.3.
Yes.
If you don't give importance to 8.3, the whole thing will collapse. Find out if this man had opted for another institute where he would have got an unreserved seat, But at the time of counseling, he said, give me GMC and the EWC. If it is so, find out which medical college it is. That medical college will get one EWS quota from Guwahati University. Guwahati GMC.
But you have to keep in mind that though in 12th college their education is going on, only 6 the EWS.
No, now only 6 you consider, nothing beyond that.
Otherwise, you come in.
No.
Others is come.
No. Again, you are not getting the point. Whether he or not he comes in some institute is not relevant. Whether by virtue of his first choice,
Yes.
that depends on the information contained in his application. Suppose this Guwahati man, he had given first choice as Dibrugarh. And Dibrugarh, he would have got an unreserved seat. But he opts for EWS in Guwahati. Then one EWS from Guwahati will be taken and added in Dibrugarh, and Guwahati EWS will be converted to UI.
This might be better. Those here opted only for 6 colleges.
Mr. Let's take up the other question.
We'll try to confirm.
Give us this information. The respondents in the medical education department shall verify the complete select list vis-a-vis the application forms of the respective candidates. And if it transpires that any candidate as his first choice institute was entitled to a unreserved seat and accordingly offered, but opted for a EWS seat in any other institute, the serial number, names of such candidates be informed to the court. Then we'll work it out. It's okay. Then we'll work it out. We'll see what is to be done.
Because there are persons,
Mr. Gugu, we'll do the workout on the next day once we get this information. On 7th.
I think one more question.
Yes, respondents. Anybody coming or not? Who's coming? Yes, Mr. Pine. See, this matter, what happened? Initially, another council appeared. So, objections were raised that from the year 2006 or something, this person is not at all appearing in the tribunal and he is evading all the time. Then we wanted to know from the petitioner why he is evading. The earlier counsel says that I have absolutely no contact, means I cannot even contact the petitioner. So the situation that arises as to whether the person actually exists or not. So we asked the superintendent of police to make an inquiry and if necessary, take him to custody and produce him before the court. Then, in the meantime, there is a change of counsel. Under there being change of the counsel, an affidavit is brought on record that this man now says that I will go and appear before the tribunal on so that I will participate. But later on, it was pointed by your authorities that we have already brought all the information regard after the inquiry by the police. So those should also be taken into account. So accordingly, we got the matter listed today. What is to be done? Just duly informed that the informant would be suitably rewarded.
In fact, this matter has taken to the DCP, CID, all that.
So now,
Then
but in the meantime, the person has appeared before the court. What to do? I think he has appeared.
Yes, yes. He was there even on 25th. This matter was on 25th when I asked. 25th day. He was here.
The orders have been taken for apprehension. But these are the steps taken by the police to find out the person, and they are yet to find. And the man is now before the court on his own.
On 25th day, I filed the affidavit. He was before this.
because I had probably informed my doctor, he was not found in family members.
And no one knows. Even the council did it. Council said that I have no contact with that man.
So my prayer is that the next person, that's okay. Whether it is because as of now,
Do you have them, your man with you?
Today he is not there. If it's on tomorrow, I will be there. If it's
Tomorrow,
on 7th,
tomorrow anyway, it won't be there.
if it's fixed on 7th.
Asking to them, will you also be satisfied?
Yes, on 7th, we can, we have put this on the road.
70. So we fix it on 11th.
On 11th?
Huh?
Yes.
Ask the man to come. Then you also, what if you ask your concerned police also to come, let him identify whether he's the man or not. The person you want to proceed, whether he is the person who will come to the court or not, you verify.
And even
If you verify and find that they're the same person, then we will see what order to be passed. And if he's not the same person, the earlier order will hold good. They'll bring back the actual one.
even the notice, as per law, notice is not served upon the,
We'll hear you later, not today.
yes, sir.
Today is only for the purpose of
Yes, sir.
identify whether this man is the man they want or not.
On 11th, he will be
Mr. J. Pine, Learned Counsel for the Home Department, has produced a communication dated 27/8/2023 from the Superintendent of Police Border Hubli, which depicts the steps that have been taken to apprehend the writ petitioner whose whereabouts were not known earlier. In the meantime, the writ petitioner himself has appeared before the court by filing an affidavit that he would go and appear before the tribunal and have the matter adjudicated on its own merit. Mr. J. Pine and Home Department raises an apprehension that a person who may have filed the affidavit may or may not be the actual proceeding that the respondents intend to proceed with. To verify the matter, the writ petitioner may personally present before the court, and the Home Department may also have their own personnel before the court who shall interact and verify whether the person who has appeared before the court is actually the proceedee against whom they intend to proceed. List on 11. No coercive action. Because somebody has come. So otherwise you don't have to now a copy of the communication kept on record.
Item 2 for orders.
Mr. Pine, there is one more matter that I have listed it for to be spoken to. Because some issues we want, because after we dictated the order, completed it also, but again, when we went through the records, some further things are noticed. So therefore, we said we will be here for some time.
Item 2.
Where is Mr. Nath? Sorry, suffering from? Oh, that one. Okay. It stated that Mr. D. Nath and said the advocate is suffering from certain medical inconvenience. They don't to be listed. Same day, 11, who is it? List on 11, 9, 11, 9. But in the meantime, I have gone through some materials which shows that it is possible. Suicide is also possible. The question that we are raising, whether it will be possible in that manner or not, whether this, in this case, what happened, we don't know. But some of the materials indicate that it is possible. So shall we close it with that 5 lakhs compensation, or we want to go a little beyond that? Close it. On 11th, we'll do it, Mr. Nath. Sorry. I think it will be better.
Item 3.
Mr. Fine, if you come to page 38, if you go by the first again, third paragraph from bottom, this is all the discussion. Prior to that, the evidence and material produced is recorded. Okay. Then from that, in exhibit 3 as per that line,
Yes.
the reasoning of the tribunal starts. First reasoning is Phalani Khatun, shown as 36 years, going by her age, name ought to have been there in 85. Okay, this is one reason. Next is Hobby Rahman and Habibur Rahman are name of one and the same person. OP failed to prove the same. This is the second reason. Okay. Third reason is PAN card not proved. We are not very serious about it. Fourth reason is Exhibit 1 Jamabandi document is not sufficient to prove that Hobby Rahman of Exhibit 1 and Habibur Rahman Exhibit 4 are one and the same person. And that apart is a draft chita not proved by production of original record. We have basically dealt with this question. We went from the point of view of section 65B of the Evidence Act. Then say for the reasons discussion above, evidence documents submitted found to be not sufficient and trustworthy. So means everything is not trustworthy. The voters list, the Jamabandi, everything is rejected. Fine. So this is a opinion where somebody is declared to be a foreigner. We have examined some orders of the same tribunal, and not only one tribunal, many other tribunals, where a person is declared to be a citizen. This approach is not there in those cases. Suppose in those cases, it would have stated that yes, everything is matching, Jamabandi is accepted, this, that, it indicates a person is a Indian citizen, therefore I declare. Very well, it is absolutely your prerogative, but it is not there. Why two different approaches? It's a little serious question. So what we would like you to do, give us some sample copies of persons declared foreigner, declared citizen by the same tribunal, at least of a few of them. I think let us go to that question. Sorry.
The same way is
Whether, see, for example, to go to Panbajar, you have to take this route. Just fill and all those. Go to Ulbari, you have to take the other route. Okay. Now to declare a person to be a citizen, you take one route. To declare the person to be a foreigner, you take another route. If you are taking two different routes, that means that determination is made beforehand. It's a predetermined. First, I make the determination and then I choose the route. I think we have to go to this question. We'll list again on the 11th. On your part, you'll get the relief. Don't worry. Madam Chaudhary, you don't have to worry, because on that section 65 part, you are getting a relief. But on the some further questions also have to be going to. So you take your seat, just allow us away. To comment the examiner session. Should they record something in the order? Hmm. Then what order I pass today? Something has to be passed today. On the prayer, Mr. J. Pike, like on home department, list again on 11 nights, 11 nights. You are protected in the interim? Good question. Sorry. Yeah. See what it happens. If it is not. The difficulty is not the decision. Decision we are not concerned. Decision we can know. You're wrong, you can always correct it. If it is right, you accept it. Approach is the something of more of concern. And if there is a big variance, what do you intend to do? Then also try to think about that.